about that they may be willing to stipulate that our open records were received and that they were not responded to within 3 days, according to statute. If that's the case, I can remove a lot of my questions. But if the court wants that testimony, then, I mean, I think if the question is when they were complied with, but I don't think anybody's arguing they were complied with within 3 days. So if that's the case, I can remove a lot of my questions.
Ms. Monroe or Mr. Bowman, who am I going to hear from relative to this
You'll be
witness?
hearing from me. So, what I did say that I was going to stipulate to is that the information wasn't provided initially, but as far as the 3-day window, I would have to double check because there are several requests before your Honor. So I'd have to double check which ones, in fact, were not responded to within 3 days. So I can't make that confirmation. If I just have like 2 minutes to check my notes to see which ones were
Okay.
actually.
I think that is time well spent because that 2 minutes might save us 30 minutes. So if you will take a moment to do that, that would be much appreciated, Ms. Monroe.
Thank you.
And regarding as a moment ago, I was talking about the rule of sequestration, just right now, it looks like we're only gonna be having Mr. Bond and Ms. Miller as an initial matter, but I just always ask, y'all know who your witnesses are and what they look like way better than I do. So if somebody wanders in, please keep an eye out. Also that applies, I'm sure I don't need to say this, but it bears repeating to anybody that might be watching on the Zoom or on the live stream. If you anticipate that you might be called as a witness in this matter, you should not be observing these proceedings. Thank you. Careful. I'll give you the same spiel. So be careful of the ledge to your left there because that chair is on wheels and I have actually had a witness take a tumble and I don't want that to happen to you.
Perfect, that would not be number 2. I appreciate it. Thank you, Your Honor.
Tell you what, since Ms. Monroe, since Mr. Bond is here, if you'll continue to keep looking, but also let Ms. Monroe see if she can at least start with some of the preliminaries. And it may be that even Ms. Merchant, it may be even that Mr. Bond can confirm what you're trying to confirm. I appreciate the effort, but just in the interest of time.
Yeah.
So, Mr. Bond,
Yes.
if you'll do me a favor and raise your right hand, I'll swear you in. Do you swear the testimony that you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you, sir. You lower your hand. Now, if you would, for the record, state and spell, there's musical accompaniment. I don't know, I'm surprised I know it was there. I thought it was the document too. I'm like,
I've never happened before.
okay. Okay.
Oh my gosh.
Okay, so I think you already, or I was asking you to please state and spell your name for the record, and then I will deliver it over to Ms. Merchant to begin her questioning.
My name is Dexter Q Bond Jr., Dexter, middle initial Q, Bond, I am a junior.
Great, thank you so much, Mr. Bond. Can you tell us what your job title is?
I am the Deputy of Operations for the Office of Fulton County District Attorney's Office.
Does that include being the records custodian?
Yes, among many things.
And before we get into the documents, I want to talk to you a little bit about the portal, how that's set up. If first, let's talk about at the time that I made the request in January of 2024. Was there a website link on the DA's website for open records at that point in time?
In January, yes, there was a link on our website, yes.
And when a person clicked on the link on your website, it took them to the county attorney's open records portal, correct?
Yes.
And there was a drop-down box if they went to that open records portal to request records from the district attorney's office.
And I can't speak to that because I don't request records from the district attorney's office.
Okay. So at some point in time from then till now, was that landing page from the DA's office website removed?
I don't have information to that, I don't know.
Do you know if the open records page, the page that the public would go to, if that link was ever altered?
Are we talking from, give me a time frame.
From January until now. So what we just talked about was in January. If I went into the DA's office website, I clicked on open records, it took me to the portal.
Yes.
A month ago, if I went on the DA's website, clicked, and there was no open records link at that point.
I cannot speak to that. I do not monitor that site on a daily basis. I do a lot of things for the office, but that is not one.
Okay, so you cannot speak to whether or not there was an open records portal site or portal link on the DA's website?
No, I answered that question. There is an open records link on the DA's website. You will click the link, you can go into the portal, you can request open records request as you, right? Oh,
So there was one in January and there is one now, right?
to my knowledge, yes.
Do you know if it was removed at any time over the last 9 months?
I cannot speak to that.
Okay, thank you. Who could?
I don't know. I don't maintain that particular website. Once the information is placed in the portal, if necessary, it will be elevated to me, and I do my job as the business records custodian. But as it relates to it sounds like, forgive me if I'm wrong, but I'm interpreting your question to be a little bit more, I don't know what you're asking me, but I
I'm
can't.
trying to ask how the public asks you for open records.
And I'm saying that the DA's office has a website. As you know, the DA office has a link that you can use. The DA's has once you click that link, it goes to a portal, which you have used several times. And once you go into the portal, you can put in your request. That's what I'm saying.
Are you able to testify if over the last 10 months that process has been in place?
I don't object just based on the fact that the availability of the link in the portal is not an issue in this case, and it's not an issue pertinent to whether the records were provided by them.
Ms. Merchant, is there a reason, is what you're really trying to get to that for the entirety of the last 10 months, Mr. Bond or someone else would be tasked with and subject to complying with open records? Or are you really trying to ask if there's an actual portal button on that website for the whole last 10 months?
I'm trying to figure out if they've had, so once I made my request in January, I had to make follow-up requests and it went away. And I wasn't able to continue to make those follow-up requests, which is part of what, when we continue
I
to,
understand the question.
make this request.
Okay,
Forgive me, I'm gonna reframe your question and you make sure that I'm not reframing it appropriately, right? Your time frame at issue is from January to the present.
Yes.
And you are asking me at any time, did that particular process deviate?
Yes,
The answer is yes.
Okay.
May I explain?
please.
Because of the cyber attack. I do know, if I'm familiar, that you received an open records request saying that, hey, we are under a cyber attack, this will require a delay, and I do know that this portal is not maintained by my particular office, right? I think you and I can agree with that they made some modifications. So if your question is, look at 10 months, did something change from the routine? The answer is yes. The reason why is because it was a cyber attack.
I'm just gonna interject very briefly. You're like me, you're naturally a fast talker. And for the benefit of the court reporter, she's already asked us once to slow down, so if you'll try to be more conscious about speaking slowly so she can take it down, okay?
Yes, Sean.
Thank you, sir. Go ahead, Ms. Marchand.
And I just want to make sure I understand. So it changed because of the cyber attack. So that portal link was at some point disabled or not available?
So you asked me, did something change? I reframed the question to make sure that we were on the same page, right? I told you, yes, something did change. I gave you an answer as to why that did change, and that was as it relates to the cyber attack. Again, the framing of your question was from January to the present for the last 10 months, right? And enter in your question, you asked me something about the last 10 days. So forgive me if
10 months, I'm sorry.
you said 10 months, but you also said 10 days. I asked you a follow-up as it relates to the framing, right? I've answered that question from January to the present. I have told you that the reason why that has changed is because of the cyber attack. I've also told you that I do not maintain that website on a daily basis.
My question was, how has it changed? You said it's changed. My question is, how has it changed?
I cannot answer that question. What I can say is that from 2021 to the present, the DA's office has had access that allow constituents like yourself to request open records. That link is displayed on our website. Once you click that link, you can go into the county's portal. I've also told you that I do not monitor that website on a daily basis. So if you're asking me how, I cannot answer that question. But if you're telling me, look at the last 2 months, if it has changed, I am telling you, a cyber attack has required a lot of things, including open records, to change.
Do you monitor the open records portal?
Do I monitor it on a daily basis? No.
Do you monitor it at all?
Yes.
How often do you monitor it?
On an as-needed basis.
As needed.
Yes.
How do requests come to you?
You go to the link, you put in, it goes into the portal.
Oh, sorry, and just to save time, I'm not asking how I do it, I'm asking how they come to you.
Once a staff member on my staff, a designated staff member for open records request, receive the open records. If it's standard, like the many of you have supplied, we can go ahead and give you a responsive record, right? If it's not standard and it requires an elevation of some sort, then it is elevated to me by a staff member.
Elevated to you?
Elevated to me by a staff member.
So the first sort of triage is the staff member reviews it, determines if they can just answer it quickly.
I would say that, yes.
And then if it's something that's more elevated, can you describe what something more elevated would be?
I'll do it the opposite way if I can. If you're looking for an invoice, a particular invoice, and that invoice has been commonly requested, my staff knows that this is a particular invoice. And for efficiency purposes, we get that responsive document to you as quickly as possible. And then if you're talking about something that is exempt or possibly exempt, that's an example of something that's going to be elevated. And not in this particular case, but in some cases, my exemptions include open and active investigations. So in those particular cases, that'll be elevated.
Were my requests elevated?
You have to be more specific. You know, you gave me about 40.
Were any of my requests elevated?
Yes, ma'am.
Were any of my requests not elevated? You can narrow it down.
I'm going to say yes because 40 was not presented to me. I know that you are a frequent open records requester. I know that we have responded to open records requests. I am familiar that you, I would say dozens, and I would not say that all dozens have been presented to me. Those have been closed out based on my monitoring. So I am comfortable saying that all have not been elevated to me.
And you said I did 40 open records requests?
I said dozens, maybe 40. I feel comfortable saying dozens. I know,
They're maintained on the open records portal, right?
yes, I'm pretty sure they are. So maybe 40, maybe 30, but I know it's a lot.
Would it surprise you that it was less than 12?
Oh yeah, I think I'll be surprised with that.
Okay, and let's go through them in a minute. We'll go through the specifics.
May I ask a follow-up? 12 an issue or 12 total?
In total,
Since when? January to the present?
correct, since Ms. Willis was DA.
That would surprise me. That would surprise me.
You all have a employee manual that you use at your office, right?
Yes,
Right. And that governs, it also talks about open records requests.
I believe so, yes.
And if you want to look, we've got, these have been admitted previously. This is merchant 0602. I believe the county attorney supplied this, I'm assuming from your office. Does that look like, you can look at it on your screen, part of the employee handbook that's given to new hires that Ms. Willis created or updated Mr. Bond's
Eyes maybe better than mine, but you might need to make it bigger, because
Okay.
my screen's pretty small and I'm
Yeah, it's
struggling.
hard to read.
So that's okay. Thank you.
Thanks. So does that look like the section regarding open records compliance?
Yes, at first glance, yes, 6.6, Open Records Act compliance.
Okay. And it says that all open records requests submitted by members of the public will be handled by the open records officer. Is that you?
It will be handled through the portal, so no, not necessary. It will be handled under my leadership.
Okay. And so handled under your leadership, but through the portal. It also says that DA employees should consider all communications that occur on county email, cell phones, and other county-owned technology to be considered open to a FOIA request.
Subject to no exceptions, yes. So I think that's consistent with the Open Record Act. I would
Okay.
agree with you.
Okay, so subject to no exemptions, county email and cell phone communications would be something that you would provide in the records.
General rule, but I think you and I can agree certain things exception. I work with 385 staff members. Of those 35, about 150 or so
Okay.
are attorneys, and we know that there's exemptions. So anything that they're working on as it relates to attorney work product or confidentiality work product are exempt. So yes, this is the general rule, but I don't want the general rule to be mistaken as the norm.
Right, I understand, definitely, there's statutory exceptions.
You and I are same page.
The statute's the
And to
statute.
be clear, the employee handbook, while it is helpful guidance, doesn't change what the statutory obligation is one way or the other, so.
No, and the reason I'm asking him is the process in their office, to try to understand this process.
And if I can clarify, I think the second sentence is certainly important, right? I know that our employees, again, I alluded to the size of the office, 385 approximately. We want to make sure that staff members who receive open records requests know what to do with it. So that, I think that was the angle.
Okay, so the employees receive this and they are told that they need to forward it to legal counsel of the district attorney when they get something.
At the time of that writing, yes, legal counsel.
This is the current handbook, though, right? I'll represent it's the one that your office provided earlier this week for Ms. Monroe.
I would say yes. If your representation is correct, I will take that as this is the current one.
And legal counsel, right now it's Ms. Abbasi, I don't want to say her name wrong. Alabi, Ms. Alabi is legal counsel now. It was Mr. Armstrong before, correct?
Yes, he was at one point.
So according to this, Mr. Armstrong or Ms. Alabi would be copied on all of the records requests received by employees?
So, no, let me deviate. The answer to that is no. The reason why is we had several different legal counsels since 2021, and based on their strengths, weaknesses, or expertise will determine whether or not legal counsel will handle that. I had legal counsel before. That was his expertise. He felt comfortable handling it. I cannot say if Kevin Armstrong handled open records, so I want to be clear. As it relates to Andrea Alabi, a dynamic attorney, however, open records is not something that she handles.
So if a member of the public was reading this and at the time they made their request, Kevin Armstrong was legal counsel, it would be reasonable for them to think that Kevin Armstrong would be apprised of their open records requests. Assuming this is followed.
No,
No.
no, I don't think so.
Okay. This also, let's see, if we go down a little bit more, it talks about emails. Let's see, email communications. This advises employees that emails are monitored, and essentially that means that you're telling them you have access to emails, or the office has access to emails, correct?
You have to tell me the line. The way that I read that is my district attorney, Fani Willis, requires us to look at emails. So 3 times a day is our standard.
If you look under section 6.9, the third line, it says to ensure compliance with this policy, computer and email usage may be monitored. Does that mean that the district attorney's office can monitor computers and emails?
Not necessarily, well, can we? Yes.
Can, that was the question.
Yes.
Okay, so you have access to emails,
Yes. I do have some. Let's be clear.
some,
Some emails, yes.
access to county files. On county computers or county phones.
Yes.
So on a county computer file email system, you've got access to emails.
When you say you,
Your office, I'm sorry.
okay.
I mean, when I say you, it's been represented, and we can pick a term if you want, but as that you're the man for open records. You're in
Okay.
charge of all of this. So
So the answer to your question is, as in you, as in Dexter, right? Yes, I will have access to that.
Okay.
Or I will request access. Is that better?
yes.
Okay.
And so this also, if you look at, let's see, after where it says only those who are directly supervised by the district attorney can send emails directly to her. So is that policy, that someone who's not supervised by her is not permitted to send emails directly to her?
We have a strict chain of command, so I think that is true.
Okay, so it's reasonable then for a member of the public who was trying to see emails to assume that emails would go through a supervisor before they went to the district attorney.
That would be a general practice, I think so.
As an open records custodian, part of your job is to be familiar with the rules with record retention, right?
Yes, to a degree.
Okay. And so you've got to, and that's actually in the, if you look on the same page, if you go up a little bit, there's a policy for record retention, and it says that all records are maintained in compliance with the state of Georgia's retention schedule. Would you agree with that as the policy of your office?
That is the policy.
So any records that the public is trying to access, they can assume based on the policy of the office that you're going to retain them based on the state of Georgia's retention policies.
That is an accurate assumption based on this policy.
While we're on this document, if you flip to the next page, 0603, it talks about county cell phone policy. It says that all investigators or attorneys are required to have a county cell phone, and that text messages, recordings, and photos within that cell phone are the property of the county. So that means that if someone did an open records request for those types of documents, that's in the county's property, right?
This is what we get here. As it relates to Fulton County's property, the answer is yes.
So it says they're required to have a county cell phone. So an attorney is required to have a county cell phone. Let's use an example. Jeff DeSantis is required to have a cell phone, county cell phone, correct?
He doesn't work as an attorney in my office. If we're going through your analogy, give me an attorney. I can't speak for Jeff.
And I'm looking, it just says all investigators and attorneys.
And Jeff isn't an attorney.
He's not an attorney?
I don't, in the capacity of my office, no, he doesn't act as an attorney.
So
ADA, yes, is required to have a cell phone. An investigator.
are you saying that Jeff DeSantis doesn't have a county cell phone?
No, I'm not saying that. You presented the analogy that all investigators and attorneys are. I understood your analogy. You gave an example of Jeff DeSantis. If your analogy is investigators and attorneys, I want to keep you honest, and I'm letting you know that in the capacity of Jeff DeSantis, he doesn't fall in either category. So I'm following you, and I offered you an opportunity to present someone else, and I gave you an idea of an ADA, because the ADA fits with your example.
Let's back up for a second.
Okay.
Jeff DeSantis, and I was just using him as an apparently unfortunate example. He is the deputy district attorney, correct? That's his job title.
His working title in the office is public relations.
Can I personally research?
Sure.
Thanks. Showing you a printout of the district attorney's website. You take a look at that and see if that refreshes your memory as to what Jeff DeSantis' official title is within your office.
Deputy District Attorney,
Thank you.
overseeing the media relations unit.
Thank you. So the policy that we're looking at, county cell phone, says all investigators and attorneys are required to have a county cell phone. You're saying that not all attorneys and investigators are required to have a county cell phone, is that accurate?
That's not what I'm saying. You gave me an example of Jeff DeSantis. I could not speak specifically as it relates to Jeff DeSantis. I'm not arguing whether or not this policy exists. All investigators and attorneys are required to have a cell phone.
Okay.
That is correct.
Okay, so all unnamed attorney has a cell phone. According to this policy, if that unnamed attorney on their county cell phone is messaging on an app on their county cell phone, and they're recording things, and they're taking photos, screenshots from an app, that's subject to the open records request.
If there's no exceptions, yes.
If there's no exceptions, thank you. Okay, let's move on to one of the requests that I want to talk about, and I have a couple different identifiers if you need them, but it's the critical mention media monitoring. Do you know if Jeff DeSantis has a county cell phone?
No, I do not know that.
You do not know that. Who would know that? I'm assuming him. Anyone else?
I don't know.
Okay. All right, so let's move on to critical mentions, media monitoring. If you need me to tell you the request, the open records number request, or exhibits or anything, I'm happy to do that, just let me know, guys. But I'm gonna globally refer to them as critical mention, media monitoring.
Okay, I'm gonna stop you here. I know that we have a lot of critical mentions. So I would prefer, for the clarity of this court, to make sure that we're specific on critical mention, because I know there's multiple.
Not a problem.
So
There are
don't-
two.
So my ask is don't globally refer to them as critical mention. if that's
I will
okay
not
with
then.
you. Okay,
Can you pull up merchant 0027, please? There are two requests. This one, just for your clarification, ends in 010924. This is my first open records request. On January 9th, I requested any and all correspondence, as you can see, to or from critical mention, including copies of contracts, payments, analytics, reports to or from critical mention and any member of the district attorney's office. Would you agree this request is pretty clear and concise?
based on my reading, yes.
And I submitted it through the Fulton Records, the Fulton County Open Records portal.
January 9th, yes.
And it was received January 9th. It says, if you scroll down a little, it shows it was received that day. That's when they return it with the reference number, that is saying that it was received.
That is correct.
Can you repeat what page you were referencing?
I'm so sorry, yes, it is a merchant 0027. And it acknowledges receipt of the open records request, correct?
On January 9th, I received that via the portal. We acknowledge receipt because you have a reference number. The answer is yes.
It doesn't say anything about whether responsive records exist.
Not on January 9th, that's the day I received it.
Doesn't say anything about proposed costs or when the records will be made available.
On January 9th, when I accepted it, no. I think that you have requested several open records requests. You've been given all the records, right, that we closed out free of charge. So there is not anything that from my office that would have a cost because I did not charge you on any open records requests that you provided.
I didn't ask that. I asked if it provided any proposed costs. Does this provide any proposed costs?
On January 9th response, this document that you put before me, January 9th, I acknowledge that it is a receipt number for tracking purposes. It is a acknowledgement of receipt and it's a description of the records you requested.
If you would scroll up, so on January 12th, someone wrote back, or I wrote, thank you, and I followed up saying I was asking for the analytics, the contract, and the analytical reports. And I was asking, following up, when I could receive them.
3 days later, yes, it appears, I don't know, Ashleigh Merchant wrote, thank you, in follow-up, I also asked for, yes.
And then on January 11th, someone, either from your office or the county, said, please log into the portal and see attached emails, correct?
January 18th.
January 18th, I'm sorry, if I said it differently.
So January 18th, based on this email,
Okay.
we gave you attached emails, and included in those emails, there were several different documents. So yes, I responded to this open record request on January 18th.
Did you type this or did someone else? Please
I did
log
not.
into the portal.
I did not type that.
The attached emails, did you provide those attached emails?
No, I did not.
Who provided those attached emails?
A member of my staff.
Who?
A member of my staff. I do not know who provided that on January 18th, but I do know that this particular request, as you said, was pretty straightforward. So we responded and it was closed out. This wasn't elevated to me.
So you never saw this request, you were not involved in this request at all?
On this particular request based on the portal, I don't recall this being elevated to me on January 18th, no.
So you can't tell us, what searches you performed looking for these documents?
I can tell you that.
You can.
Yes, this is a general request. It wasn't elevated to me. Critical mention is something that was always asked. I have several requests that are very similar to this. So I'm pretty sure, not this particular one, but one of critical mention was elevated to me, and we responded the same way we did with most critical mention.
Who did you ask?
I'm sorry?
Who did you ask in response? You said you did ask somebody about these records. Who did you ask?
So with critical mention, you ask, based on this search, you will look and you will reach out to Jeff DeSantis. Hey, do you have any emails related to critical mention? After that, you will go to the IT department to confirm,
Okay,
see if they need responsive records.
Fulton County IT Department.
Yes,
So Jeff DeSantis and Fulton County IT are the two. Okay.
especially when you ask it for emails, the answer is yes.
But you don't know if you did that in this case.
I know that I did that in critical mention. I have 1,000 cases. So as it relates to this specific request, I cannot tell you that this particular case was elevated and this was on the top of my list.
And once someone makes a request like this, what steps do you take to ensure that the documents they're requesting are preserved?
Repeat that?
When someone makes a records request like this, as an example, what steps do you take as the records custodian to ensure that the documents they're requesting are preserved?
They are placed in a portal. Once the portal is sent to you, I think that you have access to that, and I think that that is something that the portal does to make sure that it is reserved. And I can have a copy if I needed to go back to those specific documents. So as it relates to you, this is when you and I are going to make sure we're not splitting the baby. But as it relates to the portal, they are reserved.
And we'll use this as an example and sort of walk through the request. So once you get a request like this, whether it's elevated or not, what are the steps your office takes to make sure that the documents I'm requesting aren't destroyed?
Typically, once documents that you're requested are placed in the portal, right, will maintain those particular documents, right? You have an email version, electronic file of those versions, so that's in the portal. So
So, and maybe I wasn't clear. So you're telling me how you maintain the documents you give me. What I'm asking you is when I ask for critical mention documents here, okay? And you get this request and you give me some of them. How do you make sure that they're all maintained? Or do you all maintain them?
I'm gonna answer your question, I'm gonna make an assumption if I may, okay? I made a comment and I said that there was 40 open records requests. You looked and it appeared, assumption. Emphasis on assumption that you was gonna go see how many open records requests you had.
Right, it's all there.
Yeah. So the answer to your question is, it's in the portal, it's all there.
No, that's why I didn't know if you understood my question. My question is not,
I
how
just
do you
looked at
preserve
you.
your
Hang on,
response?
don't talk over each other because the court reporter can't take it down.
My apologies.
That's okay. Ask your question and then you are free to respond in any way you wish.
I'm not asking how you preserve what you tell me you have. What I'm asking is how you preserve the documents inside of your office that I request, not the ones you give me, but the ones I've asked for.
If you ask for 5 invoices, right? I'll take those 5 invoices. Those 5 invoices is given to a staff member to provide to you. So the original copy of those invoices maintain wherever they are, right? You have a copy that's filed electronically, right? It is given into the portal. So if I understand your question correctly, 5 invoices. The 5 of those invoices are sent to someone on my staff. A copy of those invoices are uploaded to the portal. Those 5 invoices, the original copies, wherever you came from, continue to stay there. Did I answer your question?
Yes, so the originals continue to remain wherever they originally were.
It depends on the particular document. If you, in my example, I gave you invoices.
Right.
We do know that invoices are electronic, right? Well, I like to think that most invoices are electronic. So in those particular invoices, wherever they are on my particular file, they stay. A copy is employed to my staff member and then uploaded to the portal.
And let's go through some specific things that you gave me, and then we can sort of go back to that question because it might help.
Okay.
If you look, let's see, if you can pull up merchant 0029, on January 18th, there was, I received this packet that we talked about of emails uploaded to the portal. What you're looking at is the beginning of that packet, and it was 44 pages. That was in response to my original request discussing critical mention. You said you did not produce this document, correct?
No, I don't believe so.
Did you assist in retrieving these documents?
For these particular documents, no. These documents appear to be responsive to your open records request. It appears to be delivered to you on January 18th, and it appears to be responsive to your request.
You can look at 0055. If you go down a little on this one, see where it's after Melissa Fritz, it says Fani Willis critical mention search. It's a different font, and then PR value for the week, and then there's a couple other things. This, and we now know, because we have the actual emails, we now know this is 4 or 5 different emails that were pieced together. Did you participate in the cutting and pasting of these documents?
Objection, Your
I
Honor.
don't.
Objection, Your Honor. Presumes that he cut and paste documents, and that was never established by his testimony, so we're objecting to that.
Okay, well, for now, I'm going to sustain your objection to the characterization of the cutting and pasting, but you can certainly ask him if he participated in the creation or generation of this document that was produced to you, however it came to exist. So your objection is sustained to that extent, Ms. Monroe.
And Judge, I thought that was Mr. Bowman's witness. I might be mistaken, but I prefer not to tag team.
Well, I do agree. I apologize. Who is going to be examining this witness?
I will.
Oh, okay. Well, then fair enough.
I didn't know that was a thing.
Well,
I mean,
Mr.
generally-
Bowman had objected, so.
Yeah, generally speaking, you know, whoever's going to be examining the witness is the one who should be controlling the objections. And I think Ms. Merchant's expressed concern was she thought Mr. Bowman was going to question this witness, which would make your objection problematic. But since you're going to be examining the witness, it's fine.
That's fine.
I'll frame for the Your Honor.
Well, usually I just ask that you whisper in your partner's ear so they can then say the thing that you want them to say.
And I showed Mr. Bowman the documents because he had made the first objection, so I just was assuming that was the path, but I will check. Okay, so this document, however it was created, did you assist in the creation of this page?
No, I think you and I agree that the first request was straightforward. I don't think that this was elevated to me. On January 18th, no, it was not elevated to me.
Who compiled the document in the form that we see it in here today?
A member of my staff. That's an assumption. A member of my staff.
Okay, so you're assuming, but you don't know who compiled this?
Specifically,
Yes.
on January 18th, yes, this is a designated employee, yes.
You're positive it's a designated employee?
Well, okay. Yes, I'm positive I know who that is.
Who is it?
Erica Willingham.
Erica Willingham. So Erica Willingham is who we would need to ask, not you as the records custodian, about how this document was created.
I cannot answer that question. Let me explain why, right? typically emails are compiled in a certain kind of way, right? And those emails are compiled by IT, by staff. It may be compiled by going to reach out to various different persons. I cannot speak to that, so I cannot tell you if she personally, if the question was, did she compile? I do not know. I do know that she handled it as a member of my staff. I do know that she responded as a member of my staff. I can tell you that.
So you can't say as the records custodian that this is an accurate copy of an original document. Let's put it that way. You really don't know anything about this document.
I do know something. I know it was responsive to your request. So yes, I know something. I think you and I can agree on that.
Okay. Let's take a look at, I'm going to jump out of order. I apologize. Let's see.
I also know, if I may, that it was provided to you on January 18th. I also know that you received this particular document on January 18th. I also know, as you mentioned, that there was a second critical mention document. And in that second critical mention, I know you referenced this before, right? I also know that once you referenced this before, you renewed a second critical mention document saying, hey, you gave me this on January 18th, I'm looking for A,
Yes.
right?
And we're in
And
there.
that's why you and I on the same page, didn't want it to be global. So I do know information as it relates to this particular request.
And we can actually go there right now. So I filed a second request because my initial request was closed when you all provided this 44-page document, right?
Yes, on January 18th, it was closed.
And so on January 18th, I refiled my request and I specifically referenced the original one and said, why are you closing this? You didn't give me everything. Did you?
If I can,
Yes,
I like the fact that you presented the first one and allowed me to read it. Can I read the second
of
one?
course, it is, let's see. I don't have the number off. The second one is. Merchant 0011. Might take a minute. Oh, doesn't take a minute. There we go. So this one I said in regards to my prior request, and I referenced that number we just talked about, and I said I requested the critical mention documents, and I say the number. I said I got a set of emails, but I asked for the analytics and the documents that are clearly referenced and attached to those emails. I said reports with analytics were provided to the DA's office monthly. It appears from the emails that Jeff DeSantis, Fani Willis, Jeremy Murray, Pallavi Perkasa, Robin Bryant, and Rita Kepler may all have access to these reports on a regular basis. They're public media, paid for by public funds and subject to open records.
Yes, I did receive that. This was elevated to me, and I did respond to you.
Okay, so this one was elevated to you, and you definitely did respond. Before we get there, let's talk about what we were just talking about a minute ago about the and I don't want to use the word cut and paste, the document, and I'm going to call it Merchant 55, that appears to have a compilation of several other emails contained within it. Okay, that document we were looking at a minute before, and you said you don't know who prepared that document, right?
I do not know who compiled that. I know who handled the file. I know who sent you the responsive document.
And you don't know where that person got the responsive documents. But you assume it was Jeff DeSantis, is what you said earlier.
I did not say that, ma'am.
You said you would reach out to Jeff DeSantis in Fulton County IT.
But he certainly wouldn't compile any documents for me.
Oh, okay.
Okay?
So who would compile them? Who would, and let's just look then. So you've seen, and can you show him again, Merchant 0055, just take a look at this document, so I'm gonna ask you to compare it to a different one.
Okay.
So just to make sure I'm clear, I thought that Mr. Bond said that he believed that Erica Willingham was the person who compiled the response at Merchant 0055.
I thought he said that she did, but that she would reach out to Jeff DeSantis and the county. First, he said he didn't know who provided it. He said that they would reach out to Jeff DeSantis and Fulton County IT.
Well,
And then
that's
later-
actually why I'm asking for clarification, to make sure we're all having the same conversation, because I understood you to be asking him about who compiled the document that was provided to you, not who obtained the information that was then determined to be responsive and compiled into a document that was provided to you. What I understood Mr. Bond to be saying was, this type of request, I would have reached out to DeSantis and maybe county IT.
Yeah.
And then it was compiled by this particular employee and provided to you.
And I'm not sure, that's the ultimate question. So let me try and be a little more clear then. This document, number 55, okay? It looks as though it's a compilation of other emails, okay? If you look after Melissa Frick's name, it says Fani Willis critical mention search, and then PR value for last week, and then there's that middle section that we're talking about, middle section right here. There's no header to, from, or dates here, there's no header to, from, dates here, there's no header to, from, dates there. That, they all look like different emails, right?
I would agree with you.
Okay, so not using the word cut and paste, someone took these parts and put them all in one.
Objection, Your Honor. Is that a question, is a statement? I mean, if it's a question to
Well,
the,
he's an adverse witness, so she can cross-examine if she wants to, number one. Number two, I mean, the reason I said we were not gonna call it cut and paste is that assumes facts that are not yet in evidence. Now, you can ask questions about assumptions that you're drawing from the appearance of the document, but that's why I said we're not gonna call it cut and paste. Now, I think the witnesses called it a compilation, so why don't we call it that for a while until we decide that it's something else?
So this appears to be a compilation of several different emails if you want.
I agree, compilation, yes.
Okay,
And if, go ahead.
no, that's okay, we're here to learn from you, tell us, what were you gonna say?
No, I'm agreeing with you. That does appear to be a compilation of emails.
Okay, and can you pull up merchant 0167? So there's a redacted section here, and then you can see under that, I sent a story via critical mention a few minutes ago, directly below. Okay, so this, and this were removed from that email. It just starts with, I sent a story via critical mention. All of that is not in that compilation document, right?
As it relates to the headers.
As it relates to the, sorry?
This,
Yes,
it does not appear to be so.
so this was all removed. And the document just starts right there.
I cannot tell you if it was removed. I think my testimony, Your Honor, is that this particular request came in January 8th, right? We responded on January 9th. On January 18th, we responded to the documents, right? Once we responded to the documents, you accepted it. What I need you to hear is we closed that particular file. It was not elevated to me. Your second one was elevated to me. Let's call that critical mention 2, if I may. That critical mention 2 referenced the first critical mention, right? In that critical mention 2 that you just displayed to me, it had only one specific item. I am looking for analytical graphs. I responded to that request. So as it relates to anything that from the first time I gave it to you, it was responsive because this is me as the business record custodian. Once I received the second critical mention reference that referred to the first, you and I can agree that the first had, let's just say, 5 things. You only made mention of one thing in the second one. I assumed 1, 2, 3, 4 was resolved, that is closed. And I responded on January 26th to the remaining issue. So as it relates to compilation, I want to be very clear. It was sent to you. It was responsive to your request. I moved on. You referenced it. Once you referenced it, it was elevated to me. The elevation was one specific item. So I assumed that the first matter was resolved. And the only outstanding issue related was analytical drafts embedded into something, which I responded to you on January 26th. Is that clear?
No,
Okay.
and so let me break it up because there was a lot, so I tried to take notes. First, you said I accepted it. So on January, whatever the date was, 18th, I accepted it. When you said I accepted it, you sent me a document and I accessed it and it was immediately closed. So you're saying that's an acceptance of the open records response?
I am saying that we sent you the open records response that's responsive to your request.
Yes.
All right. I'm also saying that you opened up another open records request. In your second open records request, that's why it's very important we do not refer to this as globally. you make reference to the first.
Yes.
You said here in court that the first one was very detailed, in which I agree, okay? I let you know that I did not have anything to do with that. You gave responsive records. Once you respond to me in reference to the first one, and there's one thing outside, I am a reasonable person, that's the word that you use, will assume that the first is over. It's done. It's complete. So I am assuming, reasonable or not, that you accepted the open records request because you said, here's the second one. I did this. I'm referencing that, and here's a small section.
So you assumed I accepted it and.
It was
Hold on,
delivered.
hold on.
Is that better?
Delivered.
It was sent to you on January 18th.
Yes.
No, there is no reason to argue about semantics of what we're talking about. It is not in dispute that on the whatever day it is that the Open Records Act portal sent you a batch of documents. And then I don't think it's in dispute that that request was closed and then you followed up on it, which the county or the Fulton County, whatever we're gonna call it, treated as a new request that referenced a prior request. We don't have to argue about whether it was accepted or received or acknowledged or whatever. The facts are what happened. Let's move on.
So you said that it was, that was responsive to my request, but it didn't completely respond, it only partially responded to my request, the first one. The 44 pages weren't all that you had.
Yes, Your Honor, is that a question or a statement?
It's a question. The 44
Okay,
pages.
hang on. When there's an objection, let me deal with it. We're just gonna put a question mark on the end of Ms. Merchant's statements, because technically that's what they are, but they are allowable cross-examination questions, so.
I want to put the witness in the best position to answer the question, so if it's not posed in the form of a question, I think that's, the onus is on her to pose it in the form of a question as opposed to a statement.
I think that right now I'm gonna, unless I believe that it's being deliberately confusing, which so far it is not, I'm going to allow Ms. Merchant to question the witness. And I'm gonna overrule your objection for now. Go ahead.
Thank you.
You have to repeat your question, I'm sorry.
The 44 pages that you sent me on January 18th, you said that they were responsive to my request, but they were not complete. There were additional documents. Now we have 197 pages. So the 44 were only partially responsive. Is that correct?
Okay, I have issue with your question, so let me break that down, okay? As it relates to you, I have testified that on January 18th, a member of my staff responded to you and provided you responsive documents, okay? So you as in Dexter Bond did not give you anything, okay, on January 18th. The responsive request for your records that sought 5 things were given to you on January 18th. The answer is yes. On the next day, as you just testified, a new open request was opened. You made reference to the first request, right? Of that, again, the first request was 5 things. You only asked about one thing. The first one was never elevated to me, okay? The second one I responded to on January 26th.
Okay. So my question, to answer my question, the 44 pages that you provided, your office provided on January 18th, that is not all the documents that were responsive to the original request. It was only partially what was responsive. Correct.
At the time on January 19th, I couldn't answer that question. I don't know. I don't know.
So you gave me or your office gave me documents, and then you have now certified 10 days ago that 197 pages are the actual.
2 different things.
Yes.
So I'm glad that we was
So,
able
and
to
hold
talk.
on. So now we've got 197 documents.
Okay.
Back then we had 44.
Let me,
Okay, hold on. Those 197 page documents, those existed in January when I made my request, correct?
I cannot say that.
You don't know if they existed?
May I respond?
If you answer my question first, I'm happy to allow you however much time you want to respond.
Okay.
Did those documents exist in January? The 197 pages? Your business record certificate?
I cannot answer that question. May I explain?
Why you can't answer it?
No, let me explain why I cannot answer it. That's correct. Let me explain. Your open records request that you presented asks for certain things, right? I'm assuming that you are talking about the production of documents that you gave on August 30th, right?
Yes.
All right. And in that production of document, I'm assuming you're saying that that was 197. What I am saying that I cannot correspond, because it's my assertion that the open records request that you received on January 18th is different in scope from the subpoena you requested. And because there is a difference in scope, because your subpoena was more specific, I cannot tell you if the two are correlated. So I cannot answer your question.
So you can't tell me if the 197 pages that you provided on August 30th, that those existed in January?
Yes, they would have existed. The 197 pages should have existed. However, I cannot tell you, let me be very clear, that the 197 pages that you received on August 30th as a response to your subpoena was responsive and should have been included in the 44. I'm afraid that you are looking at an open records request that you received on January 18th, accepted with no reservation. You're convoluting a subpoena. There's two different scopes. There's two different, your search terms were different. So yes, the 197 did exist in January 18 because the scope in which you asked for was from January 2021 to the present, whenever the subpoena came in, right? We did that through IT. Those documents you could certify. I cannot tell you if those 197 were responsive to the 44 because your open records requests and your subpoena are different. Your subpoena is more specific.
Okay, so my open records, my first one said that I was seeking a copy of any and all correspondence to or from critical mention, copies of contracts, payments, analytics, and reports, okay? So correspondence, that's emails.
More.
Correspondence is emails.
And I gave you emails.
The 44 pages versus the 197 pages. Would you agree with me that there are a lot of emails in the 197 pages that were not contained in the 44 pages? A lot of emails. We can go through them page by page if you'd like.
If that's what you prefer.
It is not. It is
Okay.
definitely not.
What I am telling you, and I need to be very clear, that your subpoena that produced 197 pages, right? It required, look at this particular email to and from, right? As it relates to these particular search terms. So your subpoena was filled out and given to the Fulton County IT department, and those 197 pages were given, researched, and provided. Let's look back at your open records request. There were no search terms. If I am not mistaken, and you may have to bring it up to reflect my memory, you just wanted something about to and from the vendor or something like that. There are two different things, two different scope. So if you're making an inference of 44 versus 197, I cannot buy into that inference because I see logically why 197 and 44 could be different.
And I'm trying to break it down simply so that we can just get through one item at a time. My original open records request, we're only talking about correspondence. You and I agree correspondence includes emails, correct?
I agree.
And would you agree that the 44 pages did not contain a lot of emails that the 197 contained?
I can concede that.
Okay. The next classification is contracts. Okay, so I asked for contracts between the DA and critical mention. Okay, would you concede that the contracts I got in the 44 pages with my open records request did not contain all of the contracts I got in the 197 pages? Would you concede that?
No, I cannot concede that. You have to show me that.
Okay, that's not a problem.
You
Which
have to
one?
show me that.
So we'll break it down even further. In the 44 pages, the original request, you only gave me a contract for the first year of critical mention, correct?
Show me.
Okay, let's see. Okay, the 44 pages start at, just so everyone knows, they start at merchant 0027. And that one may take a few more minutes to get up because we didn't have it on the queue. Oh yeah, 0027. And if you want a hard copy of the documents, I can give you that as well. Okay, in response to that, if you go through the next couple of pages, is it easy to pull up the next couple of pages? Yeah, let me give you the exact page. It's actually the next page, 0028. And I didn't have that one queued up, but we'll have it in a minute, sorry. Or I can just show you.
That's fine.
It's 0028. That's the February 2021 contract for critical mission. Oh, there we go.
I'm glad you said that. I'm glad you showed me this isn't a contract.
No, this is not. This is part of it, and if you go through.
You and I just had a conversation about emails. I conceded. Now you're talking about contracts. I told you to show me. Now you show me an invoice. Which is it? Do you have a contract?
Judge, I mean, I don't care if he asks me questions, but I don't really think it's appropriate if he asks me questions.
Well, I'm not, you're not obligated to answer the questions he asks you. I would just encourage everybody to try and maintain a tone of civility and let's move on.
Yes, Sean.
So, go back, the 44 pages. I'm gonna give you the 44 pages, okay? So you can just look at that, we don't have to,
Are you gonna point out the contract in 44?
give me 1 second.
Oh, okay.
Okay,
I'm sorry.
so my open records request to you asked for contracts. Okay? That was one of the classifications we just talked about, right?
Yes,
Okay. Show me where in there you gave me contracts.
I did. I don't believe it's in here. You could not show me, so do you want me to go page by page? Because you said that you was gonna show me.
I
You
want,
gave me an invoice, right?
Okay.
And then I said, all right, the 44, so I can go through here to determine a contract. So you put, I'll do it.
so
But you said that you was gonna show me.
I'm gonna show you the one you gave me,
Okay, no.
but that's in the second
You were
report.
talking in the context of these 44 pages. You told this court that I gave you a contract. I said, show me. You approached me with the invoice.
You gave me
I
that
told
invoice.
you-
Okay, stop, both of you. The question I think is pending that will actually help us move forward is that Ms. Merchant asked if any contracts were produced in the original 44-page production.
Yes.
And while none of us will necessarily enjoy that endeavor, it is perfectly fair for a witness to say, let me review the 44 pages and then I'll answer your question. And so if you would like to do that, you feel free to do that. But the question is,
Thank you.
was a contract produced in the initial production of 44 pages? Because I think we had agreed that contracts were requested.
Yes.
Go ahead. Mr. Bond, if you want to go through the documents, or if you want Ms. Merchant to direct your attention to something, we can do that, but the 44 pages is entirely fair for you to say, let me look at these documents before I answer your question.
Yes, I would like for you to direct my attention as you said you could.
I'm asking you to answer the question the judge just asked you that I originally asked you. That I asked you if you gave me a contract in January. We agreed that I asked for a contract, okay? So we agreed I asked for a contract. I want you to show me where you gave me a contract. Or if you didn't, tell me you didn't.
Okay, allow me to review.
Great.
This invoice. Based on what you presented to me, assuming that there are 44 pages here, no, a contract is not in this.
In the 197-page document that has your sworn certificate on it, did you provide me with a contract?
May you direct me to that contract?
I'll give you the 197 pages. It's your sworn business record certificate that you swore to the court was accurate and complete. Give me a moment to reorganize. Let's see. Would you prefer it on the screen or in person?
In person, please.
I'm going to give you one of them as an example. May I approach this?
Yes, and you don't have to ask for time.
Thank you. Call the renewal of work, what's happening?
Ms. Merchant, I'm sorry, I can't hear you when you step away from the podium very well.
Sorry, thank you for reminding me of that.
The renewal statement of work, if this is in my file, who you are, this is a contract.
It is. Okay, so what I just showed you was the contract, one of the contracts for critical mention, correct?
You showed me a renewal statement of work.
And that was not provided in January of 2024, correct?
It does not appear to be so.
I'm gonna show you another, I'm sorry,
And if I can, before, I know you're about to move on,
I'm not.
we agree, right, that there were some emails, right? We also, as it relates to the contract, you said that that there were some documents in that particular file that you have in the 197, okay? You also can agree, I hope, that on the second open records request, you brought forth, that was elevated to me, hey, Dexter Bond, I'm only missing with the analytical. So you and I can agree that any contract or anything was not in your, any open records request. We can agree to that?
No, we cannot. Can you pull up Merchant 0055, please? Oh, I'm sorry, wrong one. We just had it up, I'm sorry, 0008. I'm seeking a copy of any and all, including copies of all contracts. That is my original request.
Yes, but you and I, you received this on January 18th. On January 19th, you said, you referenced this same open records request, right? And you said, I am only looking for, I received your request, you acknowledged receipt. I am looking for the analytics inside that.
I'm not talking about that yet, and we're gonna be here all day if we go and talk off track. The first open records request, this one, first one, I asked for contracts, okay? I just showed you a contract that you gave me on August 30th. That contract was not provided in response to this open records request, not a follow-up, in response to this open records request, correct?
The answer is yes, that contract was not provided in January 18th.
And here's a contract for critical mention for 2021 to 2022. Can you take a look at that?
Yes.
That contract was provided August 30th, but was not provided in response to my open records request, correct?
This statement of work appears to be provided in August 30th.
And you certified the documents that you provided August 30th. Do you have any question about them?
No, I certified the documents on August 30th, but what I need to be clear is once the matter on January 18th was not elevated to me, I think there were two. When it came to January 26th, you requested 5 things. There was one thing in your second open records request that you brought to my attention. That was elevated to me. I assumed that on the 44 pages, everything else was responsive because you do a good job when you don't get something, bringing it to our attention. We do a good job of responding to you. So yes, you asked for 5 things on January 18th. My staff gave you 44 pages. When you brought forth the second critical mention open records request, of those 5 things, you brought forth 1. That one thing was elevated to me. So we make mistakes. If I did not give you a contract on January 18th, I would have loved as I often hear from you, to get, hey, you're missing this, just like you did on the critical mention analytics graph. You did not bring that up.
Judge, this is not responsive to my questions. I mean, at all, not even close to responsive.
I generally try to let the witness answer the way that the witness wants to answer. I will, however, say that I think we are getting bogged down in what previously did or didn't happen based on people's characterizations and understandings rather than, and I think one thing that would help, Ms. Merchant, is if you would ask short, clear, direct, factually based, and not argumentative questions. And then Mr. Bond will do his best to give short, concise, factually based responses that are not argumentative. Because I understand that both of you have a position that you wish to vindicate about what you did or what you think did or did not happen here, but we need to set that aside. Go ahead, Ms. Merchant.
Just asking you about my first request. We're on to the third category, payments. I asked for payments. How critical mention was paid, correct?
You asked for contracts in or payments, contracts in or payments on January 18th.
In this open records response, did you give me payments for critical mention?
I gave you 44 documents that I believe was completely responsive to your request.
Mr. Bond, you did not give me a copy of the payments for critical mention.
And when I reviewed the 44, I did not see a payment.
And you also did not give me any analytics, correct? In response to this one, just this one.
On January 18th, no, I do not believe. When you say analytics, I don't even know what you're talking about. Are you talking about the graph that's embedded in the critical mention? I don't know what you mean by analytics. Let me make sure I'm clear.
The critical mention analytics reports.
The same analytics reports that you asked for in the second critical mention request?
Only asking you about the first one.
So no, the
No.
answer is no.
Okay.
Not in
Did you
January
give me any of the critical mention reports in response to this request?
The answer is no.
Okay. So the 5 categories, correspondence emails, contracts, payments, analytics, and reports. You did not give me any of those 5.
I gave you 44 pages.
So now we'll move to the second request. So when I got those 44 pages and was not happy with the response, I filed a follow-up open records request. Would you agree with that?
Hang on, Ms. Merchant, to my point about argumentative, right? This is further complicated by the fact that you're also your own witness. And so your questions are not only tending to be argumentative, but filled with facts that haven't been established yet. So
Okay, and that was,
on that.
and I was drawing from what he said about me.
Then reference the document. I think that'll be a cleaner way to keep the record clear. That way we know it's a fact that's in the record.
That same day, January 18th, now I'm talking about that second open records request. I followed up and asked for more documents, correct? I'm just asking if I followed up and asked for more documents.
May I answer this question this way? You pointed out the 5 categories. Thank you for doing that, okay? In your second open records request, you asked for not more, the same documents in one. To me, that was interpreted as you have satisfied my open records request, so I cannot say if you was unhappy. However, of those 5 things, there is one thing in here that you're missing. Can you respond to that one thing?
So let's talk about that second open records request. So I submitted another open records request and asked for more items, correct?
You asked on that second open records request for the analytics graphs. That was also asked for in the first open records request.
And it was not provided in the first open records request.
It was not provided, well, based on my review today, no, it was not provided.
And it was also not provided in response to the second open records request.
So on the second one, a response was provided via the Open Records Act. That response on January 26th, footnote 1 reads, no, on January 26th, I don't know what subsection said, essentially, forgive me legal terms, I don't know what you're talking about. Your response, your ask is not reasonably calculated to put me, the business record custodian, in a position to know what you're talking about. At that time, I did not know what analytics graphs were. I didn't know what you were talking about. So you can reference my letter, which I addressed this second open records request personally because it was elevated to me.
I will in a minute, but let me re-ask my question.
Okay.
Did you provide me any analytics in response to my second open records request?
I provided you a response.
Did you?
In my response,
Hang on.
there was,
Hang on. She's asked you a yes or no question. I think you can answer it and then explain.
yes, ma'am.
Thank you.
No, I did not give you any documents. I did give you a response. That response said, pursuant to OCGA, Open Records Act, that it is not your request, as stated, is not reasonably calculated to put me in a position to know what you are talking about.
On January 24th, I sent your office a letter talking about this open records request again, the critical mention media monitoring data. And that's at merchant 0083. If you want to take a look at it, we'll have it up in a minute. Do you recall receiving that letter?
I recall receiving a letter from you, but I do know that that letter was not exclusively for critical mention.
That's correct.
Okay.
That's
just
not my
making sure.
question. My question is, do you recall receiving that letter?
Yes.
So let's look at what section of it talks about critical mention. I was following up, and this was asking to please not have to go into a lawsuit, right? That's what this letter was.
I don't know what this letter was, but I do recall seeing it. I don't know if it was a please not going into this lawsuit.
So it was entitled Numerous Outstanding Open Records Requests and Notice of Potential Official Complaint and Potential Civil Action. Do you recall that?
I don't recall the title, but I do recall receiving the letter.
Okay. And you recall generally the contents of the letter?
Yes.
And specifically, let's talk about the critical mention. I asked, and this is on merchant 0083, I outlined again what I had been asking for, and provided even more context in regards to these emails, analytics, things like that. Do you remember receiving this?
I do.
Okay. And you responded, and this would be merchant 0087 if you want to pull it up. This is the letter you referenced earlier. So this is the letter you're saying is from you, correct?
Yes.
It's not signed and it doesn't have your name on it, but you're saying that this is your letter.
Yes.
You drafted this letter?
Yes.
And
What was the page number of that? I'm sorry.
sorry, it's merchant 0087
Thank you.
through 88. The only name on this letter is Fani, correct?
You have to show me that.
You can scroll. Is the only name on this letter Fani Willis?
Are you referring to the letterhead?
I'm referring to someone who received this letter would think it came from.
Okay, well, I'm gonna stop you there because that calls for speculation, but if you could go to the bottom of the document, maybe we could see who signed it. Thank you.
And we just talked about nobody signed it. On the next page, 88, you know that you did not sign it, correct?
I will have to see the second page.
You can pull up the next page, it's 88. Here, fine. Give me-
I would believe it was the Open Records Unit or Division or Open Records, sincerely Open Records.
Okay.
So did I sign it? No. But did I draft it? Yes. Is it from my team? Yes.
Looking at these two pages, the only name from your office, someone reading this would see is Fani Willis, correct?
You would see the only name in her letterhead. Yes. It's any correspondence, I believe, that comes from the portal, any letter is going to have her letterhead on it.
My question is just, that's the only name that's on that document.
I feel like the document is what the document is. Let's move on.
Okay, thank you. This is your response that you were talking about, and just in regards to critical mention, well, actually not just in regards, let me back up for a second. This letter, you said, despite consistent communication that I was implying that you were still in violation of the open records, and you disagreed with my disingenuous implication.
Because it was. Yes, I made sure that I let you know that you are disingenuous and any implication that I violated the Open Records Act was as such. That was my word choice.
Okay, so the first request, the 5 things I asked for, you didn't give me any of those 5 things, and we've established that.
When you say
Your office,
My office gave you responsive documents on January 18th.
right? Some responsive documents with the 5 categories, and we agreed to that, the 5 categories. You said, no, you didn't give me the contracts, no, you didn't give me.
When you say you, my staff gave you responsive documents, okay? We have already said that certain things get elevated to me. You received the records. When you did a second open records request for critical mention of those 5 things, as we have said, you have addressed one. That one thing was brought to my attention, and I handled that one thing. So my assumption, okay, to be clear for the record, was that the first open records request, you received everything. I did not know what was in the 44. You did not, when you brought it up the second time, you did not make mention, right, of anything outside of those 5 things. You only made mention of one. So I dealt with that one thing.
Okay, so let's go down, look at, if you can make it a little bit bigger, where, he's referencing the actual numbers. So the open, yes, there we go. If you look at number 4, those 2 request number, the ones that end in 101924 and 011824, those are the 2 critical mention open records. You cite both of those, correct? All I'm asking is if you're citing those.
10924 44, yes, I'm citing 2.
Okay.
2 open records requests.
And we can agree, those are the 2, we've already gone through the numbers for the record, those are the 2 open records in regards to critical mention, correct?
Yes.
Okay, and you said in regards to those records, you cannot produce the records we seek, correct?
I also said, as it relates to your request, those 5 things, to view electronic communication, let me see, as written on January 24th, is not reasonably calculated to locate the records you seek. Can I explain why?
Just,
Okay, go ahead.
Ms. Fani, I'm gonna ask you about the second question, but I was gonna ask you about the first one first, and I was trying to finish that. And if we can stay on track, I will let you answer whatever you want.
Perfect.
The first line says, as such, we cannot produce the records because you do not maintain responsive records. I'm only talking about that line, okay?
Yes.
That's what that line says, right?
Yes, that's what that line says.
You wrote that line.
I wrote that line.
Okay, so when you wrote this, you were telling me that you did not maintain responsive payment records.
That's not what I'm saying. No,
You did not maintain responsive contracts.
that's not what I'm saying. No,
You did not maintain responsive analytics.
that's not what I'm saying. No,
Okay. You did not maintain responsive emails.
that's not what I'm saying. No.
Now let's go to the next line.
May I tell you what I am saying?
I assume you're saying you do not maintain responsive records.
Well, instead of assuming, why don't we let the witness do what he wants to do and tell us why?
Great.
So we said that you gave me my first critical mention open records request, right?
I'm sorry?
You gave me my first critical mention open records request that I responded to on January 18th.
No.
That you got on January 18th, the first open records request, the 5 things.
That's the second one. The first one was January 9th. The second was January 8th.
The 5 things, critical mention.
Yes.
You accepted, you received those documents, that file was closed out. The second one, we're on the same page? You said, hey, I need an analytics graph. Based on this, number 4, I am telling you, I gave you all responsive documents. In the second one, you did not bring anything else up. The only thing that you brought up was analytic drafts, to which I responded in the second sentence, I don't even know what you're talking about. So again, when you gave me the first request, I responded. When you said the second request, you brought one issue. So the first sentence is related to the first one. I gave you responsive documents. I assumed that you had everything that you needed. When you gave me the second one of those 5 things, you only brought forth one thing. That one thing is addressed in the second sentence, which says, I don't know what you're talking about. So that is how I handled number 4.
Okay. We've agreed. This request asks for 5 things, right?
For the record, you're referring to item number 4 on that
Yes. for the
document on the
record,
screen.
I'm referring to request that ends in 010924, the first critical mention request. That request, I asked for 5 things, correct?
Yes.
When you wrote this letter, I still had not received those 5 things. I received part of them, but not all of them.
I did not know that when I wrote that letter.
Okay.
What I did know when I wrote that letter was based on your second request, for the record, last three digits 824, you made mention of the first one, which only talked about analytics graphs. So I assume the first one was complete. You had everything that you needed. The first one being last three digits 924, done. The second one, 824, I assume that was the only thing at issue. I addressed that 824 in the second sentence.
So you assumed that this was completed, but you did not know that.
Let me tell you why I assumed it. The answer is yes. The reason why I assumed it is because when you brought forth 824, you referenced 924, and as you stated, there were 5 things you were looking for in 924. In 824, you only sought one thing. I would assume, I hope I'm not giving you more credit than you deserve, that if you was unhappy with 924, just like you said as it relates to 824, I'm missing analytics, you would have brought forth those things in 824. You didn't. I assumed 924 was done.
Is it possible that I believed that you had complied with 010924 and given me any existence payments, contracts, and that I believed that they clearly didn't exist because you didn't give them to me?
When it comes to
Your
you
Honor,
matching,
actually, Your Honor's, also speculation.
I asked if it's possible.
It's pretty argumentative, but I'm gonna let him answer. Go ahead.
thank you, Your Honor. When it comes to you and what I think you believe, it can be anything, Ashleigh Merchant.
Okay, listen, everybody, we need to dial all of this back. The questions are, I feel like instead of being educated, I'm listening to an argument, and I'm tired of listening to an argument. I would like to be educated about the processes that Mr. Bond follows to perform his duties, and about what you believe, Ms. Merchant, to be the shortcomings of whatever those processes are, but I'm not getting that. I would also remind everybody that I can read quite well, and that most of what we're arguing about is reflected in written documents that are part of the record that I can review. That to the extent that the parties wish to understand what was meant by those words, those are fair questions. But half of our time has been spent getting people to agree that the document says this, or the document says that. And I feel like if we would try to take off our, let's just, everybody take a deep breath, and please try not to continue to argue with one another. And that applies to both Ms. Merchant and Mr. Bond in terms of trying to answer the questions so that the court can understand what processes are followed and whether or not they were followed and should have been in this case. That's what I'm trying to figure out.
Ms.
Go ahead.
Roberts, when did you first learn that I had not received things in my first request?
The first critical mention request
Yes.
on your January 24th letter. That's when I realized, no, let me be very clear. On the first request, on the January 19th email, when you had made reference to the first one, you said that I am receipt of your records. These things are outstanding. That is when it was elevated to me, and that's when I became aware that you was missing analytic graphs from critical mention.
When did you first learn that I had not received the contracts that I requested in my first open records?
This lawsuit.
When did you first learn that I had not received the payments?
This lawsuit.
When did you first learn that I had not received the emails?
You did receive emails.
All of the emails. When did you first learn of that?
This lawsuit.
When this lawsuit was served?
No, during this preparation for this hearing.
So this lawsuit was served 7 months ago? Is that when you learned that I hadn't received any of these items?
Objection, Your Honor, was asked and answered. That question was asked and answered.
I'm gonna rule objection. I'm just trying to, I don't understand if you're making an argument, you're just trying to direct the witness' attention to a particular date. Go ahead.
When you say you learned about it when this lawsuit? Was it when the lawsuit was initially filed?
No, during the preparation for this particular hearing.
So just recently?
Recently, as it relates to critical mention and the lack of compliance, as you allege, with the first open records request. Because again, I resolved that matter And again, the second one was brought up to me, and of those 5 things, you only made issue with 1, which I responded to on January 26th.
And I'm gonna go to, merchant 0011, if you want to go look at that. So this, when I got at the top to please log in and view the letter attached. That letter was from the office of the county attorney. Did you have anything to do with the drafting of that letter or this entry into the portal?
I don't know what letter you're referring to, I'm sorry.
It's at 0362 if you want to pull that. So, and just so the judge, so we can educate her for a minute, because I have one sorry. When this says that on the portal, I get this email, and then I have to go to the portal to see the letter, right?
I take you at your word.
Okay, well, we'll have to get this one. All right, so this letter. This letter that was received, and you can see it's got the open records request, and again, it's merchant 0362. This letter that comes from the office of the county attorney, it says to please log into the portal to see the letter attached. The request is being extended for research. That was sent on January, I think it's January 25th, January 25th. Did you have anything to do with this letter?
No.
And if you go to 0364, this is the next letter. This is February 7th. It says due to widespread outages, the request has been extended. Did you have anything to do with this letter?
So it's gonna be hard for me to explain. At this time, it was a cyber attack. The county attorney, because we use the same portal, gave us a template letter that we all use. So I can't make reference to this particular letter, but I do know that my office, had to send all requesters, including you, an update because of the cyber attack. And that letter appears to be a letter that I sent for all open records requesters at the time.
So this was sent February 7th. This was after you sent me the letter that said you didn't have your responsive documents.
I cannot speak to this particular letter. You said, look at this letter. I know that this is a template that so many people use. So I don't know if I did not send you anything on February. I don't know. That letter was sent to everyone around that same time on February saying, hey, it's a cyber attack. Things will be delayed because we have limited access and things will need to change. As referenced earlier in our conversation about why the portal may change, and I alluded to cyber attack, this was a cyber attack. This is a general letter that wasn't just sent to you, it was sent to so many different other people because the cyber attack impacted how we handle open records and what we can do, how we can research and respond.
You can skip ahead to merchant 0167. This is a document out of your business record certificate from August 30th. Did you redact that redaction that you see in the middle of the page?
No, I did not.
Okay. You certified these records and signed a certificate and affidavit, correct?
I did sign an affidavit that is correct, assuming that this record is in the 197 that I certified.
Yes.
What's the question?
Did you certify these records as complete and accurate?
The 197?
Yes.
The answer is yes.
Yes. And you did not do this redaction, and who did?
My counsel,
Your counsel did this?
as it relates to this particular, yes, I'm pretty sure.
Miss, legal counsel for the DA's office?
No, Ms. Allaby did not do that.
Who did it?
I don't know. Let me clarify, because I'm not sure the line of question. I think that you received documents from me on my team that was redacted information. Typically, redactions are consistent. Do I do them? Yes, sometimes. Did I do them here? I don't think so, but I don't.
Before preparing for this hearing, did anyone reach out to you about the complaint we filed with the court, the open records lawsuit?
This one, my counsel.
And, you've been the open records officer this entire time, correct?
Entire time since when?
Since January of 2024.
Yes.
I'm talking about the critical mention payment. If, we've agreed that we ask for invoices and payments and things like that. So I want to look at one of them. If you could pull up merchant, 0371. Does this appear to be a payment voucher for the, for critical mention service to be paid in 2021?
Fulton Board. I'm gonna say yes, it's not the voucher that I typically look at, but this does look like a payment voucher.
Maybe look at the next 2 pages, see if that looks more familiar.
Oh, yeah, there we go.
That looks familiar.
Mm-hmm.
And so this
Just for
would,
the record, that was a yes.
Yes, I'm so
Thanks.
sorry.
so this document, for the record, thank you, Judge, is merchant 0372. This would be a payment for critical mention, correct?
This will be a payment voucher for critical mention, telling the county to, or informing the county that this particular payment is good to them.
Okay. And can you pull up merchant 0290? Do you recognize this document?
I have been presented to this document, yes.
You've been presented this document, do you recognize it?
Yes, I'm sorry.
Did you sign this document?
Yes, that looks like my signature.
And this is the check from Fani Willis, DA of Fulton County.
It appears to be so, yes.
Okay. And you've never provided me this document, correct?
If it's not in my 44 pages, the answer is no.
And who maintains this checking account, this bank account? Who maintains the records?
Who maintained?
Is it a DA's office checking account?
Fani Willis, DA of Fulton County.
Who maintains this? You signed it. Who maintains these documents, this record?
I do.
And so you're the one that maintains checking account statements and this payment receipt, canceled checks.
The count, I'm not sure I'm understanding the question. When you
Your
say,
checkbook. Is that,
you said what? This
is
is
it your check, like who retains it? Who has the checkbook?
the office.
And as the records custodian, you have access to this checkbook.
Yes, I can, yes, that's correct.
What steps did you take to obtain a copy of this canceled check or bank statements to provide me to show proof of payment to critical mention?
Your first open records request, I gotta go back to it. I gave it to you as it relates to the response, and it was not elevated to me. Based on this particular lawsuit and preparation for this hearing, the steps that I took was to pull into our AMS system. Our AMS system looks like a PBX, right? Similar to what you.
Hang on, sorry. You've just thrown out a bunch of abbreviations. I have no idea what either of them mean. So if you could educate me, I would appreciate it.
This is the education process. Forgive me. So, standard protocol. If you're looking for payment of vouchers, I would not go to a particular check, right? I will go to, in my AMS system, my financial records, our purchasing department, to say critical mention has a vendor code. Let's say for the purposes of this conversation, vendor code 123. I will go into AMS, I will look and say vendor code 123, how much payment has been calculated. So it would look as if it's the original PBX. The Fulton County
PBX is,
payment voucher, I'm so sorry.
thank you.
So vendor code critical mention 123 was paid $10,000 and paid from this particular funding line, X123. To me, based on your, not necessarily your open records question, first one, but based in preparation for this litigation, that's what I would have done. Go to AMS to show you, hey, here is the proof of payment.
This check would not be in there, though, correct?
No, typically no. No.
Because this did not go through the county payment voucher vendor process, correct?
I cannot say that.
So my question again was, what steps did you take to obtain a copy of this check?
I did not take any steps to do this check. As I understand the subpoena issue, right, preparation for litigation, you wanted payments and or proof of payment. My proof of payment would not have been this form. Instead, I'm trying to explain, my proof of payment was to go into a financial system to show critical mention, vendor code 12345 was paid $10,000 in disbursement account on this particular date. That's typically my process.
You didn't provide us that. We've never been provided whatever this process is you're talking about, that proof. So
It's-
you've never provided us that though, but you're saying that that exists?
If it was not in my 44 pages, no, I did not respond. I thought on the first critical records, everything was resolved. I only moved forward from that first one with one issue. So as it relates to payments or anything, I have not moved forward with that because I thought it was resolved. So to answer your question, no. Now let me be very clear, as it relates to any checks of that matter, as I understand what you were seeking for, it was proof of payment. I would have did proof of payment a different kind of way.
Would you agree that this is proof of payment?
That is one type of proof of payment. The answer is yes.
A canceled check, you would agree, is proof of payment.
I would agree that's one type of proof of payment, yes.
And we talked earlier about records retention and that you have to follow the Georgia records retention. One of those policies is for your office to maintain for 5 years all canceled checks.
If that's what I'll stipulate to, if that's what the law is, yes.
And you comply with that law?
Yes.
So you would have had a copy of this canceled check?
I would also have various, yes, the answer to your question is yes, along with other various different forms of payment. The answer is yes.
Okay, and none of those were provided to us in response to our open records request?
If it was not included on 44, the answer is no, it was not provided, as I thought it was, as I assumed they were.
I only have one other question about critical mention, and then we can move on. Do you have a critical mention account login, or have you ever had one?
No,
So you would not have access to the online portal for reports and things like that for critical mention?
no one would. Now we don't have critical mention right now.
Okay,
So-
you've never had that?
But no, I've never.
So if there was an open records request asking for information that someone obtained in that portal, that's not something you would ever maintain?
So I cannot say that. Critical mention is something that, just like LexisNexis or something like that, I don't use my username and password often, but if there's a record, I have several different databases as the business record custodian. If I have access to it, I can pull.
So
So
you didn't have access to it? Right?
I can get access. I think you and I discussed as it relates to the employee manual, right? And then you made a reference, and you did very well, saying, hey, every investigators and attorneys, they have phones and text messages. So you brought that up. Then I said, hey, yeah, if they have it, I can have access to it, right? So the answer to your question is yes. If there's a system as the business records custodian and pursuant to the employee manual that you introduced to this court, yes, I can have access to it.
So if someone had the critical mention software or app on their computer or their phone, and they were running reports, you would be able to access that information and provide that in response to an open records request?
Not to your open records request. Because on January 1st, 2024, or whenever you requested this analytics, one, I did not know what you were talking about, right? And then two, the critical mention did not exist. So no one on my staff right now can go into critical mention and provide any data because critical mention does not, we do not have critical mention. So no, I could not provide you at the time the open records received responsive documents that you see, nor can anybody else in my office. What I could do is look at, like you gave me for subpoena number 2, which is more specific to your first 2 open records requests. I can use those particular search terms, and then I can give it to the Fulton County IT department, who has the ability to reach, well, reach and try to find out information, which I did, right? And then which I provided to you, I think you referenced it as the 197. So that's what I could do, but I cannot go into critical mention. Neither myself, let me be very clear, or any other employee go into critical mention to pull anything.
Right, the people who actually had access to that at the time, those are the people that would have to pull that.
So I think that you and I can agree that open records do that records exist at the time that open records received. We made a lot of mention here that the first critical mention open records request came in January 8th, 2024. I think you and I can agree that on January 8th, 2024, we did not have critical mention. Based on the renewals that you showed me, we did not have an existing contract. So my position is neither myself or anyone with a login. The login is irrelevant. You could not get it because at the time your open records were received in January 2024, both of them, we did not have critical mention.
The law that we agreed earlier that you have to follow says that all records created or received in the performance of duty and paid for by public funds are deemed to be public property and shall constitute a record of public acts. Would you agree that reports paid for by public funds would be a record of public acts and public property?
I cannot answer that based on the framing of your question. I'm afraid it's misleading. Can I respond? My response is critical mention is something that is a database. Maybe we can educate on critical mention. Critical mention is a system that you can, an app, as you say, and then you can go in to get stuff, right? We use it for investigative purposes if there is for various different reasons. Because HR is under me, I use it for morale. If one of my employees do something great and someone reports to that, I want to be able to let my team know, hey, this is what we're doing in the DA's office. That's how it is being used. Now, what I need you to understand is once that system is gone, that contract is gone, I cannot maintain, preserve, the system is gone. So I hear you as it relates to your assertion as it relates to the retention act, but I need you to understand that this app is somewhat, it's not a file that I will have in my office that I will have to maintain with the retention act. Am I clear on that?
Yes, you have to actually actively want to maintain it. You have to print it and actively do something to try and maintain it, right?
If you have to want to.
You have to, it's an app, and if you want the reports to be retained, you have to download them, or you have to print them. You have to somehow do some act to make them be retained, correct?
I can go with that particular argument.
Okay.
But you have to also understand, just like any private company, and I think that you've seen in one of those emails, the 197 emails, that they're always saying, hey, look what critical mention can do. Hey, look what, so it's one of those things that I don't think that I'll just show my age a little bit. As it relates to, I'm not going to an app, Instagram, to print, to retain. It's not one of those systems. I think that the court needs to be educated on what kind of system it is if you're going to implicate or try to infer that we was responsible for maintaining anything in that database under the Retention Act. I'm not gonna let you make that correlation.
But you were never the person who actually went in and did the reports and stuff. That was other folks. That wasn't your job.
Oh, I have staff that can do things like that. I don't.
Okay, and the people that had the records would be Jeff DeSantis, Fani, Willis, and then Robin Bryant.
No, that's not true.
Who else had passwords to critical?
Jeff DeSantis had a password. I recall Robin, who's no longer with our office, had a password. I believe that password was sent to someone else. But I can assure you right now that District Attorney Fani Willis did not have a password. She can't work a printer. So that's not her. That's not her gift. She's blessed at a lot of things, but she would not have a password for that.
That's undisputably not you, and definitely Jeff DeSantis does.
Yeah, I would think that Jeff DeSantis would have a password, and undisputably not me, and undisputably not District Attorney Fani Willis.
I'm gonna move on to the confidentiality agreements.
Okay.
So we have another open records request, and we've got it up ready for you. It's at merchant 0345. Would you agree that on January 9th, I requested any and all documents that employees, staff, or independent contractors, and I include agreements, are required to sign regarding speaking to the media and/or confidentiality. Would you agree that I made that request?
January 9th, 2024, yes, you did make that request.
And that request was clear and concise, correct?
Not necessarily concise, and I can explain why, but based on this reading, I understand. I understand the open records request. My interpretation of this was that she was looking for statements that exclude people from talking to the media.
It clearly says confidentiality on this document, is that correct?
It does, yes.
So would you agree that that is clear and concise as far as confidentiality agreements?
As it relates to speaking to the media and or confidentiality, just looking at this, I would agree that this is clear and concise, just looking at this.
And it was submitted through the Fulton County Open Records Portal,
That's correct.
and it was received, it shows it was received the same day, January 9th. That's the return with the tracking number, so that's proof that it was received, correct?
That is proof that it was received by our office and we acknowledged it via the Open Records Act, yes.
And then on January 18th, it looks like I got a response that said to please allow for 10 business days for a response, correct?
That's pretty standard, yes.
So would you agree that within the 3 days of my filing this open records request, I did not get anything that said whether responsive records exist, correct?
Based on this, you got an acknowledgement of we received it and you got an R, so I don't know. Outside of this, and I would have to agree with you that you did not receive whether or not responsive records exist in that 3 days time, so I would agree with you.
And I didn't get anything that says when they will be made available or whether they will be made available, correct?
If you could scroll down, I can tell you exactly what you did receive.
Oh, no, go back up to the request. Yeah, that's it.
And if you go down to,
I asked within 3 days, so you can definitely.
so for January 9th, this is what you received. Thank you for sending your open records request. Here's your tracking number, here's your description of records.
So, and going up on January 18th, that's when I received a response that said, please allow 10 business days, correct?
That's when you received a response through the portal. I do know that you and I, as well as my staff, exchange emails. I cannot tell you if you received a response anywhere between January 9th and January 18th. But just off this record, you received a response on January 18th. Please allow 10 business days for a response.
And while you mentioned that, your staff would email me for clarification if they thought anything was confusing, right?
My staff is instructed to, if you get an open records request and it's simple, go ahead and handle it, right? And I think you and I can agree on what is simple. My staff also knows we have routine checkups when anything that's elevated come to me and let's discuss. I do have competent people on my staff who sometimes will reach out to people to ask for clarification. I do have that.
And so the letter that was attached, if you can go down to the next page, it's merchant 0346. That's the letter that I received in response, correct?
Once your request has been reviewed, this is a pretty standard letter. I would say that you received that.
Okay. And so this was received 9 days after I made the open records request, correct?
If this letter is consistent with the January 18th, the answer is yes.
And this is from your office, right?
It is from and signed Open Records, although, as you can see in the headline, who it is, but you know it's from Open Records. You do know that, right?
I'm trying to differentiate between the county attorney's office, which we've received some letters, and your office. This is from your office, correct?
Yes, because it has my office's letterhead.
Yeah, but if I could ask for a point of clarification on that, there was another letter we saw earlier, it's the one that related to the cyber attack, that it appeared to be on
County attorney letterhead.
Ms. Miller's letterhead. The signature line said Open Records Team.
Yes.
Is that distinct from your signature line of Open Records?
Yes, and let me explain. And this is what I was trying to get to. The county attorney decided, hey, everybody that's involved in the portal need to use this standard letter for cyber attack. So that particular letter, as it relates to cyber attack, we were supposed to go and say to all our requesters, he is a cyber attack.
Right, no, that's fair. But actually my question is broader than that. It's not about that particular letter. It's about, is Ms. Miller and her Open Records team the same as Mr. Bond and his open records?
The answer is no.
Thank you. Okay, go ahead.
And so after I received this letter, let's see, is this, can you scroll down a second? Is this, 4-6? Yes, okay. I followed up with a letter, the letter that we talked about earlier, the January 24th letter. I sent that to your office.
The January 24th letter came. At that time, like you said, there were several different things that was elevated to me because at this time, this wasn't elevated to me. It was interpreted to me at that time of that letter that you wanted any documents that prevented staff or independent contractors from speaking to the media.
Okay. Let's, if you can scroll. Maybe on the next page. And this is the same, that's the same follow-up letter though that I included. I included essentially all of my requests, correct? The ones that were outstanding.
It's more than 12, so I don't know if you said, earlier you said it'd be surprised 12, you remember? This looks like more than 12, so I don't know if it's all. That's something that you can clear up for the record. You remember I said 40, you said 12, this looked like in between. So I can't tell you if it's all.
Number 5 on here, if you look at the top, is about confidentiality or non-disclosure agreements, correct?
Yes.
And here again, I'm asking for confidentiality agreements.
Yes, I would agree. I would also say, let's look at the context. Let's read it. It says, district attorney required to sign regarding speaking to the media. To your point, and/or confidentiality. So yes, I said signing, speaking to the media, to which I responded. Let's be very clear, you go on. I had no responsive records to any of my staff speaking to the media. That's how I responded.
Can you pull up the employee manual page down? Page, the employee manual. 0602. The employee manual actually contains provision that, if we can get it up here for you, but it actually has a provision about talking to the media, correct?
No employee is permitted to talk to the media. I believe, I'm referencing this.
And that's in the employee manual, though, correct?
It should be, you can show me, but I'm almost certain, because no employee should be talking to the media.
So if you interpreted that request to mean you can't talk to the media, you didn't provide this in response, though, correct?
This wouldn't be responsive to you asked for, let's go back to your open records request, because the two like minds were different. We learned that in law school, right? Look at your open records request. You're looking for agreements signed by staff. This is an employee manual that says you are not to speak to the media. In my professional opinion, based on my years of experience, the employee manual will not be responsive to your request. So the answer to your question is no, I didn't provide it.
And so in that letter, you didn't provide the confidentiality agreements, you didn't provide any of those, correct?
No, you're right about that. Now, I did not provide confidentiality agreements. The way that was presented to me was the media. I knew I did not have responsive records after talking to counsel, right? Let's be very clear. In your subpoena.
No. I'm not asking anything about the subpoena. I don't want to confuse the issues.
Gotcha.
I'm only talking about the open records. We are still in January.
I got you. So as it relates to open records, I interpret this as you do not talk to the media, to which I responded, you're right. I do not have responsive documents as it relates to making my employees sign an agreement that says you cannot talk to the media.
Can you put,
And it happened in January, that is correct.
put his letter back up, 0345. I'm sorry, Mark, yeah. So go back up to the open records request, the actual wording. So I asked for documents, agreements, contracts, memos, or any written documents that anyone's been required to sign regarding confidentiality.
So
It says media and confidentiality, so hold on.
I agree with you.
So in response to this, you did not provide any confidentiality agreements, correct?
The answer is agree to sign, so you know our employees don't have to sign employee manual. So we know that. So we know that that's not responsive. As it relates to the media, I'm agreeing with you, right? You asked for, I interpret this in my staff, you wanted media agreements. I responded and said, I do not have responsive documents, right? After this particular litigation in preparation for this hearing, at that moment, it was confidentiality agreements, right? And at that moment, I believe as we sit here before, they have been provided to you.
So they were provided to me 2 days ago, correct?
I cannot tell you when it was provided to you, but I do know that you have them, because once I've been informed, hey, this, if I can, this particular has been a moving target. The first one, not perfect. I interpreted it as media. Once I said it's media, it's non-responsive. Later on, it was interpreted as, forgive me, Jeff DeSantis made comments to the media saying that these agreements were destroyed. To which I said, I don't have any responsive records. And then at that moment, it then turned to this most recent, I think, subpoena, was just pure confidentiality agreements. So yes, I agree. Put it down to confidentiality agreements, and you got confidentiality agreements. My interpretation is on the onset was media. Based on context that you provided, hey, the DA's office had some stuff, they destroyed some stuff, which I did not have that. And now confidentiality agreements I have. If I have it, you have it. There's no,
In January, in response to my
I did
open
not give
records
you any
request,
confidentiality
you
agreements.
did not give me any confidentiality agreements. In your letter in January, when we said, we're going to have to file a lawsuit to get these if you don't give them to us, you responded, you do not maintain responsive records and cannot produce the records we seek, correct?
That is exactly, because I thought that the scope of that was the media. You're absolutely right.
And you actually provided a custodian affidavit with a confidentiality agreement signed by Nathan Wade in his divorce proceeding, correct?
You have to show me.
His, Nathan Wade's, or his business records. If you don't remember that, I'll get it for you.
As a business record custodian of 1,000 files per year, I don't remember that particular one, but
It's, merchant 0610.
yes.
That's a business record certificate that you signed in November, oh, it's on the screen for you now. November of 2023, correct?
Yes.
And attached to it is a confidentiality agreement, is that correct?
Yes, a confidentiality agreement, not agreement to speak to the media. As I told you, wish I was perfect, I am not. When I got your open records request, I thought it was exclusively, you cannot talk to the media based on context that you provided.
Context I provided? Can you put my original open records request back up?
Not via the open records side to me.
I'm sorry?
Context you provided, you're going to the open records side. I am not scoped to the open records side. I'm saying context that you provided, because you did provide it.
Right,
But
we're gonna put it up. And you can show me where.
But I'm telling you, it's not in the Open Records Act. In one of
So
your
there's no context in this, is that what you're saying?
only context is required to sign regarding speaking to the media.
And there's nothing in my letter where I said, if you don't give me these, we're gonna have to file a suit. There's nothing, it provided anything different than this, correct?
That's not true. Not in that letter on January 24th,
In regards to the confidentiality.
I do not believe that. But there's been emails, right? No.
I'm sorry?
On January 24th, you did not make any mention, you did not provide additional context as it relates to the speaking to the media on January 24th.
So when we had to file the lawsuit, the open records case here, you had not provided any confidentiality agreements in response to this original open records request,
The answer is
correct?
no. as I thought that your request was limited to the media, so no, I did not have that.
Would you agree that the 22 documents that were provided recently, within the past week, would be responsive clearly to this request?
I agree, it is, for, as it relates to confidentiality. If it was presented to me as, hey, this, we're looking for media and or confidentiality, I would have gave you those, but again, I interpreted let me take responsibility, I interpreted it as a NDA, a non-disclosure. I discussed that because I interpreted it as a not to speak to the media.
And in regards to this confidentiality request, did you perform any searches in response to this open records request?
This is an example of, I will go to my investigative team, do these exist?
So in response to this, you went to your investigator team and asked if any of them existed?
Not in response to this, let's be very clear.
What did you do in response to this?
I interpret this as the media. I know that as a business record custodian, as a deputy of operations, I know that we do not have any requests related to employees, any signed forms saying that you cannot speak to the media. I know that to be certain. So I did not do anything as it relates to this open records request based on my interpretation, and my interpretation is because required signing regarding speaking to the media. So let me be very clear. For that open records request, I did not do anything because I read it as required signing regarding speaking to the media.
But you personally thought this was elevated to you for some reason?
This was elevated to me, and when it was elevated to me, it was presented to Mrs. Merchant want media statements. Do they exist? No, they do not exist. To which I responded to your open records request, they do not exist.
Were all of my records requests after January 18th, were all of those elevated to you?
No, I don't. You have, again, we disagree on the number. We know there's a lot. If you have asked for my office back from September, a lot of standard things, all of which we responded to in a timely manner. I hope you can agree to that. So I don't see all of your requests.
Did you sign a confidentiality agreement?
No,
You've
I don't
never
think
signed, you've never signed one?
I don't think so.
You don't remember?
I don't remember, I don't think so. I do not think so.
Do you believe that only 22 employees of the district attorney's office have been required to sign a confidentiality agreement?
I don't have no belief, I don't have a position on that. I know my staff, I could speak for my staff, no. And what I think I gave you were,
I'm sorry? You think you gave?
no, I can speak for me, I don't believe I signed one. I know that my staff, my direct reports, they have not signed one.
Your direct reports have not?
As it relates to my direct team, I did not administer, I did not facilitate the signing of those particular documents. So I cannot speak to that.
So at this point, the 22 that we've received, I heard testimony of 150 lawyers, 300 and something staff. Is it your testimony that in response, and we now don't have any semantics confusion, right? Like it's confidentiality agreement. Is it your testimony that only 22 confidentiality agreements exist from Fani Willis as the district attorney's term?
Based on my research and based on me asking around about confidentiality agreements, I provided that.
All right, let's talk about your research then.
Okay.
What did you do to respond to this request?
Security team, do we sign confidentiality agreements? This is, executive assistant, do you have confidentiality agreements? Chief of staff, do we have confidentiality agreements? Oh, we do? Who? Why? Okay, get these, let me give these to the council. So that is a standard, when you get a request, hey, I'm looking for confidentiality agreements. I think that you can respect the fact that, hey, do we have them? Do we have them? Let me show due diligence. Do you have them? Do we do them? Do we have them?
So you did not do that in January, you did that recently?
That's correct, because in January, as I stated, I thought it was limited to the media. I know media doesn't exist, so I did not very clearly do it in January. I did not.
And in response, you asked the security team, the executive administration, and the chief of staff if they had any of these non-disclosed?
Hey, remind me, hey, these was maybe done 4 years ago. Is this something we did? Do we have them? Who have them? Are they made? So yes.
What I'm trying to understand is if you're saying, swearing under oath, that 22 are the only 22 that exist.
I cannot tell you that.
You're
I can
a
tell you-
custodian, right, for this office?
So but I can tell you what I did. When I got this, when council presented to me and said, hey, media, let's go, instead of looking at it from a narrow scope for media, let's look at it from a confidentiality agreement. Dexter Bond, as the business record custodian, what did you do? And I'm answering the question as what do I do? Now you are looking at my efforts at what I did, and you're trying to conclude that my efforts yielded to a totality result. And I cannot confirm that. I can tell you what I did in good faith.
Did you send out an email to all staff saying, who has signed a confidentiality agreement? Please respond. It's
Oh,
been
I didn't do
requested.
that. No.
Did you send it out to all supervisors?
No.
Did you send it out to all attorneys?
No.
Did you send it out to anybody?
I'm not sure if I sent the email. I don't know. I made some calls, and I had my team make a call, so I don't know. But I know only a handful of people can do RDA. I can tell you that right now, so I know that.
You can now, right?
You said what?
You can.
Oh,
So if you wanted to, you could send that out.
if I wanted to, I wouldn't have. Yeah, if I wanted to.
So,
But also, if I wanted to, yes, let me tell you why I wouldn't though. I think you can respect that I get probably 500 to 1,000, maybe 1,500 emails a day. There's no way that I would send an RDA email and I would have to transport, hey, put this in this portal, so I would not have done that.
so how'd you get the 22 that you gave us?
I think I answered that question. I told you I called the chief. I answered that question.
As to how you got it, like literally how you got it.
I believe it was scanned to me.
Who's
It was
the
provided and scanned to me. Can't tell you. I signed this.
I'm sorry.
I assigned it to someone.
Oh, who did you assign it to?
Probably my team. Hey, I need to do this. Can you take the steps? In a staff meeting, I cannot tell you who specifically did it. And I made some calls. That's why I know I had an email. Do we have this? Do they exist? Is this familiar? And that's what I did.
So you asked some staff, and you don't know who that staff person is, to make some calls to see if these exist.
So when we're in a staff meeting on Tuesdays, right? I have several different people that sit around the room, right? And then I would say, hey, these are outstanding issues. This is my elevation time. Like if there's an issue, let's elevate this. And hey, you need these things for open records. Hey, can you take the lead on this? Take the lead on this. Take the lead on this. Report back to me on Thursday as it relates to what we did, how we did. In the meantime, I'll make some calls to figure out where we are. So that's my routine practice on open records.
And that request was done roughly within the last 2 weeks.
Oh yeah, that fairly recently. Because again, when I first got the request, I thought it was related to the media. As my student counsel said, hey, let's look at confidentiality agreement and let's make it a little more broad. I followed those instructions and I did, and I told you what I did.
Is there any way that I could have been more specific without using the terms actual confidentiality and agreement?
If I could, to be honest with you, no. Now, because this was elevated to me, I wish that this was a request that I would have read myself and not allow it to be paraphrased to me, because I thought that this was required regarding speaking to the media. I gleaned it, okay, speaking to the media, and then I went ahead and said, hey, listen, I don't have it.
I'm sorry, who paraphrased this to you? I thought this one was elevated to you.
When it gets elevated, it's a series of things that get elevated. Hey, these are things that I look. There are certain times that I'll look and I'll read. I don't know what you're talking about. Let me read this. There are other times where it's just like, I'm looking for X. I will briefly look at it. Oh, okay, let's go. So I just want to be the elevation process. Let's educate. On Tuesday, we sit around the room. We have open records conversations among many things. Once that happened, if there's an elevation process, it was, hey, here are 15 open records items that we have. Do we have this? Do we need this? Is this an exception? Do I need counsel? Do I need to research? Do I need to redact? That's how it happens. Some of which are, hey, do we have media non-disclosure agreements prevent staff from media? That's a paraphrase. Or, hey, this person is asking for such and such and citing the law and such and stuff. I don't. Those are ones where I'm like, hold on, wait. So I want to be very clear.
I want to be very clear to you because I'm a little confused now. So if it gets elevated to you, that's when you talk about it in these meetings? But otherwise you don't?
If it's a standard invoice, I thought I answered that. If it's a standard invoice or something simple, it doesn't get elevated to me. It gets handled by my staff.
Okay, so only elevated ones get talked about in this meeting.
I mean, in this meeting, or, hey, Dexter, I need you to look at this, I need you to weigh into this. Yes, it needs to be brought to my attention, but if you're looking for something as you have, a specific contract, if you're looking for something specific, and it is clear, it cannot be interpreted any differently, then yes, well, my staff has full reign.
So you don't personally review the request when it's elevated? It can be paraphrased.
There are times where if I have a 20 open records request that needs my attention, there are some that I can go through, I will take a quick gander. There are others that will require me to, hey, I need to make a call, I need to do something, I need some consulting, so that it's hard for me to tell you there's one way to handle 1,000 open records requests in a year.
And other than Erica, who you've mentioned, who else is on this team?
It depends. For example, if it's a big redaction project, I have to add someone. If it's a media project, I have to. So it varies based on staffing levels, workloads, and actually what I need to do.
Well, I don't want to blame the point, but you were saying that some unknown staff, you can't identify who it is that would paraphrase this. Who else is?
No.
Erica.
Okay. As it relates, I have one designated open records person, right? That what she has the authority to elevate. As it relates to handling matters, then I, because she's the only person, have the authority to say, based on the totality of circumstances, I need you to handle this redaction.
Okay.
I need you to look into this particular exemption. I need to. So let's be very clear. I got one person that open records is all they do. But as you know, sometimes redactions, exemptions, interpretations, those things can be out,
I want to try and get through the last couple areas. The next request I made, and this is at merchant 034 in case we need to look at it, was for, I specifically said, I am seeking personnel records. That's the first.
I would have to look at that open records. Oh, okay.
It's merchant, for the record, merchant 0340. On January 8th, I said, I am seeking personnel records. And then I said, I'm requesting a list of attorneys with their names and date of hired by the district attorney since Ms. Willis became district attorney. And again, I stated, including the date of hire. This request was clear and concise, correct?
No.
It was not.
No. I'm seeking personnel records. I think you and I agree. What personnel records? That's a little overbroad and stuff. Then as it relates to the second part, I'm requesting a list of all attorneys with hiring dates, hired by the Ms. Willis, the district attorney, Fani T. Willis, and to which I responded. So the first sentence, I'm seeking personnel records. I didn't know
You didn't know what?
personnel records, that part right there. I'm answering your question, was it clear and concise? The answer is no. Based on the first sentence, I'm seeking personnel records. The second sentence, you say that you need three things. A list of attorneys. Those attorneys need to have a hiring date, and that hiring date needs to be hired by Fani T. Willis. That's what you're seeking. To which I responded, I don't have responsive records.
So if you did not think that this was clear, did you reach out to me for clarification?
No, and I won't reach out to you.
And I think we agree it wasn't responded to within 3 days. I don't know.
I didn't agree to that. I'm telling you right now that I responded to that open records request, and I said I don't have responsive records.
I was asking if we agreed to that because I know Ms. Monroe was looking to see if she
Right,
agreed.
but in fairness, the witness
Yes,
didn't
I know, and I was trying to finish
That was a
that.
conversation we had before. Ms. Monroe, did you ever have it, I know we decided to go ahead and get started, and it seems like it's a good thing that we did. Do you have any insight as to whether there can be a stipulation about whether the responses that are at issue in this litigation, the requests that are at issue in this litigation were responded to within 3 days?
Okay, so the request regarding the forfeiture reports, that request was submitted on January 18th, and a response was sent for an extension on that same day for 5 days. And then a letter, I'm sorry.
I was getting the question.
And then a response was given back January 28th. So there was a response within the 3 days. It was just for an extension, but not for the provision of records.
Okay.
So,
Y'all can educate me to the extent you need to, but my understanding is that a request for an extension of time to locate documents can suffice sometimes, but at some point, there has to be production of documents within the requested time period, right? So if it's give me a document, within 3 days, you have to acknowledge the request and say, here you go, or we need more time to find it, which is okay, but then if you say we need 5 days to find it, you have to give it to them within that time you said for it to be timely. Have we followed that trail and determined if we can agree that records either were or were not provided within either the 3 days or the time period requested by the DA's office to comply?
okay, so as it pertains to the forfeiture reports, documents were not provided within 3 days.
Okay,
And then ultimately determined that there were no responsive records. And then in terms of the requests regarding rebranding, promotional materials, that was not in 3 days. And in terms of, there were also no responsive records for that. And in terms of the list of hirees, which she's talking about right now, so yes, so that was actually responded to timely, but not with records, but with a response saying no responsive records. So we had the response that was submitted on the 8th, and then on the 9th, a letter, which is the following day, a letter was sent saying that we need 7 to 10 business days to accommodate your request, something to that effect. I don't have a letter in front of me, don't quote me, please. And then on the 18th, which is within that 10-day period, there was a letter saying that no responsive records that was sent to the requester.
Okay.
So out of the, sorry, I only gave, how many did I do? 1, 2, 3. And for the final one, the NDAs, the request regarding NDAs, that was not responded to timely, and nor were any responsive records provided within the portal under that request.
okay, thank you.
You're welcome.
Thank you. Okay, so this was filed January 8th, this record, and the response was lodged January 9th that said you were in receipt of the records and to allow 7 to 10 days for research. Would you agree that the response within 3 days did not say whether or not responsive records exist, correct?
I would agree with that, but it did consistent, as I read, the Open Records Act lets you know what time frame, based on staffing levels and workloads that I'm gonna be able to provide you, and it reads 7 to 10 business days, I need to do research.
And it doesn't say whether documents will be made available.
On the next day that you gave me this document, I could not make that determination. I needed to do research, so I outlined how long I needed to do research on 24 hours. Was it 24 hours? Yeah, about 25 hours after you received that. I acknowledged your receipt and I told you I need more time.
And then on January 18th, you responded that no responsive records exist, correct?
Let's see, January 9th, I told you 7 to 10 business days. Within 7 to 10 business days, I said, hey, we don't have any responsive records.
So that's correct?
That is correct.
And we're still referring to the personnel records request, is that correct?
Yes.
Okay.
Thank you. What efforts specifically did you do to actually locate these records?
Talked to my HR team, and I know for certain because HR reports to me that I do not have a list of attorneys, 1, hired by District Attorney Fani Willis, 2, with their hiring dates. Those are 3 variables that you wanted. I know for certain that I don't have that.
What searches were performed?
I talked to my HR team, and then at that point, I know that I do not have a list of all attorneys hired by the District Attorney Fani T. Willis with the hiring date.
And you also then received, after this, so this was on January 18th, I filed a letter on January 24th, again, asking for these documents. You received that letter, correct?
I do, and again, that particular letter had several different open records requests that was outstanding. Can't remember the number. I know it was more than 12, and I think I told you the same thing I told you on the 18th. that there are no responsive records, because as I sit here today, I don't have any responsive records.
My question was, you received a letter from me January 24th where I asked for these again, correct? Did you receive a letter January 24th?
Yes,
Where I asked for these again?
I don't know if you asked for them again. I received a letter on January 24th, as we already said, that letter had several different open records requests. Yes, this is probably included in the letter of more than 12 open records requests that I addressed from your January 24th letter.
Give us a minute, hold on. I have a hard copy. It's 0080. For the record, it's 0080 through 0085. Just give you my copy.
Thank you.
Take a look and tell me if that refreshes your memory.
January 24th letter, I'm assuming, so direct me, you're talking about section 3?
Section 3.
Yes.
So I again clarified, asking if this meant that she had not hired any attorneys or that you just were claiming that you didn't have a list. Okay? Is that correct? Did you receive this?
I did receive this.
Okay. And before we move on, how many number requests are in this letter? You can look at the last one, they're Roman numerals.
Hold on, wait. Well, look at this number 1. You see how many is in here? So how do you want me to handle it?
So each are one request, so if you want to look and see how many.
Sorry, Ms. Merchant, I can't hear you.
I'm sorry, here, I'll take it back and go and ask them.
Okay, go ahead.
Sorry, I forgot. All right, isn't it true that we go up to Roman numeral number 10 in this document? There are 10 requests in this document.
Ma'am, look at number 9. That is 2 requests in 9, so you cannot correlate Roman numerals to requests.
2 requests in number 9?
Look at 3, 4. I'm sorry, don't know Roman numerals.
Objection, I'm sorry. I understand that counsel is trying to get to the contents of the letter. At this point, I don't see the relevance in having the witness count the number of requests in the letter, so if we could just get to it.
Just part of the argument has been that it's burdensome, that I've requested 40, we started with. There's 10. One of them I had to duplicate because it was closed without being responsive. There's 10.
Your letter, I can read your letter.
Okay.
I know how to count and read, right? And so there's no point in arguing about it.
You responded to that letter and said nothing exists,
In
correct?
this letter, you presented 10 Roman numerals that dealt with a lot of different requests that was outstanding, but you so kindly forget that we have had several different open records requests outside of this particular letter, dating from September. So this letter only deals with open records that was outstanding. Each Roman numeral deals with various different requests. Let's be clear.
My question was, if you sent a letter in response to this.
You asked me that 3 times. The answer is yes. You received it on January 26th.
And it said that you do not retain records and cannot produce.
And I told you that 3 times because as I sit here, I do not have records. I do not have a list of hires from attorneys with the date of hire that was hired by District Attorney Willis. I told you that on the 26th in response to the open records request. I told you that now. And I told you that previously.
One point of clarification, because you've said the same thing several times, and you're putting emphasis on a particular part that I'm curious about. Call it the rule of judge's interest. But I understand, and I think I started this hearing with this discussion about sometimes we know things that don't exist in a document. But you keep saying I don't have a list of attorneys with their hire date who were hired by attorney Fani Willis, the DA Fani Willis. Weren't all the attorneys in the DA's office hired by Fani Willis?
Oh, no. Where's the DA that was hired by District Attorney Paul Howard?
Well, I'm certain they have worked for the DA's office for a long, long time. But didn't she decide to hire them when she became the DA? Yeah, and I'm not challenging you, I'm just asking to make sure I understand if there is or is not a distinction.
I see that, yeah, I can see that.
Okay, fair enough. I mean, but at least I understand better why you were drawing that distinction. Okay.
Well, I was drawing that distinction because that's what she asked for.
Okay.
And
No,
I got you.
I wasn't challenging what it said. You were placing emphasis on it in a way that to me seemed to inform how you understood the request. And now I have a better understanding of how you understood the request.
Thank you.
Okay.
Thank you, Your Honor. I will say this, based on this particular request, what I have done is to reach out to the chief, human resources of the county to see if I have a list of, hey, here are the list of attorneys hired by District Attorney Willis with their hiring date. And I can tell you right now, as I sit here, I don't have that.
When did you reach out and make that request?
Doing it to the county HR in the course of this litigation.
Okay, so not when I filed the open records request.
I didn't have to at that time because I know I didn't exist. So the answer to your question is no, I didn't feel the need to reach out at that time.
But then in response to the litigation, you did feel the need to reach out and actually ask the question?
Well, once litigation is, I'm like, okay, what can we do to resolve this matter? Is there anything extra? I feel comfortable. Let's be very clear. Under the Open Records Act, I did what exactly is required to be a law. Now we're in litigation. Let's see if there's anything possible else that I can do. I did that extra, and guess what? The records still don't exist.
And I know we already verified that as the open records officer, you were charged with maintaining records under the State Records Management Act, correct? We already talked about that, right? Early on, that's part of your job.
The Office of the Fulton County District Attorneys seeks to maintain records inconsistent with the State Retention Act.
Okay.
Yes.
And that act requires that your office maintain records documenting an employee's work history in a case file, including the date they were hired, and if there's no hire decision. And you have to keep those records for 50 years or 7 years following the date of separation of the employee. And you're mandated to actually keep them in your own office. You can't delegate that responsibility to a central agency.
So you're reading the retention law, and I have not read, but I can tell you this. You started the sentence saying as it relates to personnel files. So you said case file date, right? In your open records request, you're looking for a list. I'm afraid you're misleading the court because you're convoluting a retention record that discusses personnel files, but you're seeking via the Open Records Act a list. Those are two different things. So let's not put the list into State Retention Act. They're two different things.
Did you have personnel files?
Go ahead.
Did you have personnel files?
Did I or do I? Yes.
Both. Did you?
Yes.
And you did.
Yes.
And do those include the date that someone was hired?
Yes. The personnel file should have the date that they was hired. The answer is yes. Do I have a list? No. I don't have a list. And if you think that it is reasonable for me to go look at find out who was hired by the DA, pull that HR file, scan that HR file to make a list, I don't think that the Open Records Act requires me to do so. So as I sit here, no, I don't have it, and I told you what I did.
Did you have a question?
Nope.
Okay, sorry. Thank you. Your office also produces newsletters with lists of all of the employees of your office, is that correct?
Office morale, yes. We have bi-weekly newsletters, winter reports, we have quite a few.
And it's got something called a directory of attorneys?
Yes, that's the directive.
Okay. And so someone has to get this data somewhere with this list of attorneys, right?
I don't, unfortunately, what graphics does report to me, I don't know if they got a list of that, but I can tell you, I'm not, can I take a look at it again?
Sure.
All right.
While you're looking at that, I need to do a sort of check-in with my attorneys. I understood that the court reporter had made arrangements to be available until 5. Mr. Bowman had indicated he had an issue. Do we need to adjourn? Can we carry on in your absence for an hour? Can you stay? Where are we on that, Mr. Bowman?
Yeah, I can push it for a few more minutes, but I mean.
And so that's all I'm asking.
Oh, I think we're comfortable concluding 5-5.
So we're just
So
gonna
for-
continue on at 5 and understood that if you need to go for your prior issue, then you're free to leave and you don't need to ask my permission, by the way.
Thank you very much, Your Honor.
Okay. Thank you for the interruption. While we were doing that, the witness had an opportunity to look at whatever it was that you were showing him. I saw it, but I don't know that it was ever identified for the record. I
Oh, I'm
apologize.
sorry, Judge. I am showing him what is base stamp. It's, exhibit 8, it's merchant 0303, and it goes until 0336.
Thank you.
Let me know when, if that refreshes your memory.
I have reviewed this directory. I don't understand the relevance, so I'm pretty sure you'll educate me, so, yeah.
This directory is published by your office, correct?
Yes.
And it contains,
Can you repeat that? I'm sorry, I couldn't hear you.
sorry, this is a directory published by the district attorney's office, correct?
Yes.
And it contains a directory, which is a list of district attorneys, essentially.
This looks like my supervisor to me.
That,
So district attorneys, yeah, supervisors, yes.
and, you guys publish these pretty regularly. The district attorney's office publishes these regularly.
When you say publish, yes, I print out, I hand out, yes. I've learned that staff like to see their faces places, so yes.
And in this, you welcome new hires.
I'm pretty sure that there's a version of, hey, we have some new hires.
And someone gives that data to whomever makes this brochure with new hires, correct?
Yes.
So you're able to give a list of new hires to the promotional people?
I did not say I gave a list, ma'am.
Someone's able to give that data in some form, whatever form it's in, to this people.
We have new student orientation. They can be sitting there typing in the graphics saying, new hire Dexter Bond. So if you're telling me that a list exists, I'm telling you it does not. If you are trying to say that a list of attorneys hired by Fani T. Willis with the hiring date, which I don't see here, exists, I'm letting you know right now that it doesn't exist. I don't know what correlation you have, but I see your directory, I see it. I see this supervisory, just not a list of all attorneys, I see it.
Your office pays attorneys bar dues, correct?
Bar dues? Yes.
And they pay for continuing legal education?
So that's interesting. Do I pay for the training to go to the class? Typically, most cases, but you know, the $12 that you have to go to the bar to say that you have the 13 credits, now the bar, here's the $12.50 to make your account for the bar, I do not pay that. That was my inarticulate way of explaining it, but I have several different staff members who want both payments, and I only do one.
Let me see if I can drill down on this for a moment. I don't think there's any dispute that the district attorney's office knows what attorneys work for it and probably knows somewhere when those attorneys were hired. Is that fair,
That's it.
Ms. Merchant?
I would assume so.
Okay. As I understand, the disagreement here is that the DA's office understood you to be asking for a list. I think I've seen something indicating their position and some case law that says they're not required to create a record in order to respond. And so I understand that you're trying to inquire about where other lists might exist, but I do want to be clear that you're not suggesting that that the defendants should have produced the personnel records of every employee that worked for, every attorney that worked for the DA in response. You were asking for a list, correct?
Yes, well, and so understanding open records, and normally, so purchasing, finance, all of those divisions, when I ask for an open records, if there's some confusion about this, they talk to me.
I understand all that. The only thing I'm trying to drill down on here is that you continue to ask questions about things that clearly indicate the DA knows who works for the DA.
Right.
I don't think that's really an issue. I understand you might be trying to get list adjacent,
Oh,
but I want to be clear that you're not saying they should have given you the personnel files. What you're trying to get to is you think there are things that might be a list that they could have produced. Is that correct?
definitely. When I worked with the public defender, there's a list for bar dues. There's a list for CLE.
Thank you.
That's what I'm asking for. Yes. Saying these lists, have existed. They have to exist to pay bar dues and things like that. So that's exactly what I'm asking. All right, so The next area was what I would consider rebranding and promotional materials. On January 17th, 2024, I requested, and this is at Merchant 0025, for the record. In that request, I requested any communications or correspondence between purchasing and the DA's office. And some of this was resolved and did not result in the lawsuit, but number two, the promotional materials. I requested any payments, requests for payments, hiring bids, paying vendors, promotional material, including promotional brochures, flyers, or mailers. Like this, promotional material. Can we agree this is promotional material?
What about, no, because no, that is promotional.
Okay, for the record, you're holding up
I'm
something.
sorry,
Can you
I'm
say what it is?
So sorry.
That's okay.
I am holding up what was Merchant 0303, the front page of the Fulton County District Attorney's Office Winter Report 2024.
Help me to understand, and maybe, I'm not trying to disagree with you and I'm not trying to belabor the report, but what am I promoting in there? Why would that be promotional material? Promotional material to me is, our REACH program, helping the youth. Let's promote that. Our records restriction program flyers. Let's, those are the things that could be considered promotional materials. I don't know. I wouldn't consider that promotional material. I don't know what you're talking about.
Okay, so you considered REACH to be promotional material. Did you provide me that in response to this?
No, because you said in this particular open records request, any payment request process for hiring, bids, paying vendors, promotional material include. So no, I did not.
Rebranding. So when you walk in the district attorney's office and there's new, new advertisement type things, did you provide me any of that?
No, I don't know, because I do not even know what rebranding is. And for the record, remember, we just had a conversation about promotional material. As it relates to this open record request, you can agree. It's just like our first one, right? It's 5 different things. Of those 5 things, I responded. I think you told the court some of this has always been resolved because some of this did not come in. You said that's what you testified to the court. Hey, some of this stuff did not make it to litigation.
Great.
All right. So we also know once I gave you those responsive records, moved on. It was closed. So I gave you what I had as it relates to that. So if I did not give it to you when I responded to you, no, I did not give it to you.
Would you agree that this request was submitted on January 17th through the Fulton County Open Records portal?
It appears to be so, yes.
It appears also that the request was received the same day.
It looks like I gave you a tracking number, and it was the 17th. That's impressive for my staff, so yes, kudos.
And it didn't say that whether or not responsive records exist or if they would be made available, anything like that, correct?
Well, on the same day, no, I certainly didn't think that you were gonna get a response on the same day. So it was acknowledgement of receipt, a description of your records, and a tracking number for you to find your record.
Then on January 25th, you put a response in the portal that says to review attached letter and that the request had been extended for research. Is that correct?
It does appear that is the letter that I gave you in January, dated January 26th, I believe. And it looks like I needed to do some research. So I agree with what's being presented to me.
What efforts specifically did you do to locate these records?
Well, I think that as it relates to these particular records, I gave you, number one, I guess this starts with 5. This is why things are difficult, right? You gave me 5 things. I responded to some. So as it relates to those particular records, I researched, retrieved records, and gave you records.
You believe you gave me records in response to this?
As it relates, you gave me 5 things in this open records request. Let's go through the first one, right? As it relates to number 1, I think that you told this honorable report that some of these matters have been resolved, right? I gave you those records for number 1. We can agree to that. Is that fair? As it relates to number 2.
No, it's not. I received number 1 in regards to a subpoena in a criminal case from the county attorney's office. I did not receive that from you in regards to the direct request. So
We're gonna have to disagree, let's move forward.
So let's go through this then. This document, 0025, the only response you sent was on January 25th, where it says, please log into the portal to review the attached record, it's been extended, correct?
Let's look at that letter, yes.
It's, if you can scroll up a little, it's higher up. There we go. Okay. And then, the letter that we're referencing is that same letter that you gave us earlier, it's at merchant 0087.
That deals with a whole lot of open
Yes.
records requests.
Yes.
So let's go to that letter,
And that's
let's look at 011724.
It's 0087.
00. Okay,
And you wrote, in regards to this request specifically, that this office does not maintain responsive records and cannot produce the records I seek.
show me.
It's number 5.
Number 5. So that's 01924. Right? Number 5, 0192.
Oh, so the
So you
request
changed
is
it,
to go,
I'm confused.
so the original request
What's the word?
is, oh, you'll go to the next page then, it's 011724.
Zero zero one seven. Okay, you can direct me.
It's number 8? Yes. Number,
If that is 011724 related to promotional material rebranding, that's how I responded. Number 8, yes.
so you never provided any records in regards to this response?
I cannot say that because that is not my contention. You asserted to this honorable court when you started looking at this open records request that this 5 things, some of them have been resolved and there is no longer in this litigation. So I cannot tell you 1, 2, 3, 4, 5 what I didn't do. I will take you at your word to say that some of those things, 1, 2, 3, 4, 5, was provided to you. So I'm not willing to say I gave you nothing when you have said, hey, I looked at it, some of this stuff has been resolved.
Do you have any knowledge as to how some of this stuff was resolved?
Objection, Your Honor. So it's my understanding that as it pertains to this request, that the only issue at hand was regarding the rebranding materials regarding rebranding and promotional materials. So
And the critical mention payment.
Okay. So tell me, Ms. Merchant, why in response to Ms. Monroe's objection, why if some of these documents have been provided to you at some point, in some manner, through some method, why is it relevant today that they were or were not produced in response to an open records request that you served or provided to the state?
It's not at all, but he said that part of this was responded to, that he responded to part of it, and that's not accurate. They did not, the open records people did not respond to any of that. It has been made moot outside of that in a separate litigation, so I didn't
So-
include it in the lawsuit. But he is very literal with these words, and so I was trying to, like, that one request is not an issue, it's trying to save time by taking that request out. But then the witness has now said, well, then we complied with it, and they have not actually ever complied with that. So that's not accurate.
Okay. Again, I think we're getting bogged down in semantics. The fact that the information and data or documents that were sought by plaintiffs at various points through their open records requests have now at some point been provided to them is not the same question as were they produced in response to this Open Records Act request, and if so, when? And so to the extent that's the conversation we're trying to have, that's allowable. And with that clarification, please go ahead.
Thank you, and I'm trying to be clear. So in regards to this request, what did you do to actually locate any records?
Received that particular open record request. I went through it. I cannot tell you if this particular request was elevated to me. I do know that I do not know what rebranding is. I do not know that I do not know what promotional material is. I do know that I responded to that I cannot speak generally about this, specifically about this open records request, but I would have done to this request what I have done in all.
Did you ask for any clarification if you did not understand what the term promotional material or rebranding meant?
I will not, I've said this to the record and I'm gonna repeat this again. I'm not having a private conversation with you, Ms. Ashleigh Merchant. So no, I would not contact you. I am not going to email you. I am not going to talk to you to look at any clarification. I find you to be extremely disingenuous, so I won't talk to you. And clarifications don't require me to reach out to you. What it does for the open records request is require you to put me in a reasonably calculated situation to give you what you have. But let's be clear. If you think that I'm gonna reach out to you and talk to you, I'm not.
The fourth request, critical mention, any payments, requests for payments, bids, or paying of critical mention. Did you do anything in regards to that request?
So we talked about critical mention. That
Because
was,
I had to ask for it a third time. And so in regards to the third request, where I asked for the same check that we now have gotten from critical mention, but not from you, did you do anything?
so I'm gonna repeat this for the third time. The critical mention came in on January 8th. On January 18th, I gave you 44 pages. On January 19th, you renewed the request. Again, the first request had 5 different things. On January 19th, you only elevated one thing. I assumed on January 18th, you got everything. Because when you don't have something, you elevated that one issue. I then worked to work on that one issue that was elevated. So to answer your question for the third time, no, I did not give you anything on January 18th. I assumed that the records was responsive. And they were complete.
You gave no records in response to this request. None.
According to number 8, I said the Office of the Fulton County District Attorney in its normal course of business does not maintain responsive records. As such, we cannot produce the records you seek. Number 8.
I asked you what you did to locate the records to give me that answer.
Mhm.
Who did you ask for records, if anybody, to give me that answer?
Let's go back.
Who did you ask, if anybody,
I have to see the
to
request.
give me that
This
answer?
request was 5 different things. So if you, again, 1,000 requests, right? What we have discovered right here is all your requests came in from September and a lot came in January, right? So in this particular January, I have to go back to it to tell you what I did on these 5 open records requests. So if you can put those things back on the court, I can tell you.
Well, I'm not asking about 5, I'm asking about number 8. It's open records, number 8. That's the only one I'm asking about.
Gotcha. So we can agree that number 8 corresponds to your open records request. Your open records request seeks 5 things. If you can put those 5 things on the screen, I can answer your question as to relate what I did for 1, 2, 3, 4, 5.
Okay.
I can make 2 easy. As it relates to branding and promotional, I don't even know what you're talking about. So I told you, let's move on.
Merchant 0025. All right, here it is.
Number 1, outside counsel. That was a.
I'm not asking you about that, so we can move on. I haven't asked you about that.
Okay.
In regards to number 2, I know you said you don't know what promotional material means, but what, if anything, did you do in response to try to find responsive documents for this?
Can I tell you what I did specifically? That's a conversation with staff, because my POV may be limited. What are promotional materials? I don't know. So I don't know what I did specifically. I don't know what. But what I did do is say that I do not have any process for hiring and bids for paying vendors for promotional material. I don't have that.
Number 3, rebranding. Any payments, requests for payments, process for hiring bids and paying vendors for rebranding material. Did you do anything in response to this request?
As a COO of the office, I know about bidding, and I know that there is no hiring or bids related to period. As to certain things. And then as it relates to rebranding specifically, I don't know what that is.
Did you do anything in regards to this request?
I reviewed it, I accepted it, and consistent with the Open Records Act, I gave you a tracking number and I responded to it. So yes, me or my staff did something to this.
did you do any searches or request any records in regards to this?
As it relates, I'm gonna say yes. You don't wanna talk about number one, but I'm pretty sure that I did a search because you have those responsive records. As it relates to number two, promotional material, I told you I do not have process of hiring bids. It doesn't require me to do research on that. As the COO of the office, I know the answer to that question. As it relates to rebranding, I think the court and I can all agree, right? That this particular matter, I don't know what that is. As it relates to critical mention, I have discussed several times what my position is as it relates to critical mention. And as it relates to TDI, I did respond. There is no responsive records to that. So did I do something? Yes, I responded in compliance with the Open Records Act. That's what I did.
So my question was, what did you actually do to locate the records? Did you perform any searches?
There were no searches to perform outside of number one. So I'm pretty sure I did a search for number one. As it relates to number two, there's no search because there's no process for hiring bids for promotional material.
So tell us what you did in regards to number one then, since you brought it up.
What I would do with any payments, because you requested a lot of payments, right, in previous open records. You requested a lot of contracts. That is something that I can pull as it relates to EMS and provide to you.
So in regards to number one, can you tell us what you did?
Again, Your Honor, this is outside of the scope of what open record requests are at contention here. If we could just focus on the open records requests or the materials that are missing and that have not been provided.
Judge, I think that you deserve an answer though, that nothing was done.
Hang on. I'm gonna save you the time and trouble of making that argument and say, I agree with you that what he provided in response to this request isn't relevant, but the process that he followed, the effort that he made to respond to it versus others, or in a similar way as he made, as a process he followed to respond to others, I think is relevant, and so I'm gonna let him answer the question. Your objection's overruled.
Repeat the question, please.
In regards to request number one, outside counsel requested a payment, request for payment, process for hiring bids, paying outside counsel, including the reference retraining, which was discussed during the Board of County Commissioners meeting in November 2023. You'll remember you appeared in front of them. There was a big discussion about this. What did you do in response to that open records, number one?
I cannot recall specifically. I cannot recall.
Do you recall if you did anything in regards to this?
I can speak generally what I would have done. I cannot recall specifically as it relates to this request.
So how can you tell us that it's been fulfilled then if you don't know what you did?
Because as it relates to outside counsel, I cannot specifically tell you what I've done. Generally, for payments, I would have looked to see if there are any outside vendors, which you have asked me for via open records request, and I have supplied to you responsive records to this. So I don't know how to answer your question, and I cannot specifically talk about tracking number 11724.
What did you do to search for information about the retraining that was required during the Board of County Commissioners meeting? And you remember attending the Board of County Commissioners meeting in November 2023?
I do.
And you remember there was a big discussion about the DA's budget for things, printing, promotional material, things like that.
That's not how it was reframed, but I do remember that I was present and I represented the office at that BOC meeting.
And the purchasing department had some concerns because you had quite a few outstanding debts or payments.
What department?
Purchasing.
Purchasing.
Sorry, had concerns about all the spending for promotional material.
That's a mischaracterization of the purchasing department.
Okay, I don't want to get down into the weeds of what, because also there's an official record of what went down at the BOC meeting on whatever day, and if it ever becomes relevant, I can find it and listen to it and know what was said. So let's begin.
Yes, okay, what is relevant is what did you do in regards to when I asked for the communication that was referenced at that meeting? Purchasing said they had gotten with you on retraining your office about purchasing. I asked for that communication, it was referenced during that meeting. What did you do to find that?
That particular training was done by me and the CFO. It was a conversation between me and her. So there is no documents related to that particular training. It was done via Zoom. So that's how, again, I cannot tell you specifically what I did with this open records request. If the conversation is about this particular training, I can tell you what it was. I can tell you that your statement of the purchase department is mischaracterized, and I can tell you that there are no records related because that happened via Zoom and we had a conversation. about how to proceed forward.
So you did nothing in regards to looking for correspondence about that, setting up that Zoom or anything like that?
I know I would not set up the Zoom, so, no.
Let's move on to the forfeiture reports. So on January 16th, this is at merchant 0019. January 16th, I requested reports and itemization for all property and funds obtained through forfeiture.
If you can, don't recall the characterization of that open records request. If you can allow me to see it, I will definitely bring you up to speed. Yes, for me.
And this was submitted through the open records portal.
Yes, it appears it was submitted January 16th. Good job, staff. They responded. They gave you a tracking number on January 16th.
And the response, or the request was clear and concise, correct?
Actually, no, it was not.
So you didn't understand what I was requesting here?
No, I didn't. And I communicated that to you.
You communicated that. How did you do that?
January 26th letter.
You communicated that you didn't understand what I was requesting?
If you can pull up the January 26th letter, I can reference what you're saying.
Sure. And the base.
Do you have a physical copy of that letter you can give the witness? For reference to the amount that having to stop and pull it up each time is. Thank you.
Thank you.
So before you go any further, is this the first time you responded to me in regards to this forfeiture request?
No.
Okay, well, you said that what I was asking for was not clear and concise.
That's correct. So, and I told you that. And you gave me this letter, and I'm about to tell you what I communicated. Is that fair?
So you're gonna tell me where you told me it was not clear and concise?
Yes. You want me to tell you?
That'd be wonderful.
Let's look at the letter, January 26th. I'm gonna direct your eyes to footnote number 1. Footnote number 1 reads, we believe, emphasis on we believe, you are seeking the office's equitable sharing agreement and certificate. These records were filed in accordance with law, state and federal law. And I want you to, let's go back up to number 6, because you're talking about 011624. I say to you, responsive records are attached. So in this particular letter dated January 26th, I respond to your open records request number 6. I let you know that these records are attached. I give you a footnote, and that footnote lets you know we believe. And if I can, don't want to talk too much, but let me tell you why I believe what I believed. You want me to go there?
No, I mean, if there's something that's relevant to this, but, I mean, this is the only response that you're saying you have, right?
For number 1, yes, as it relates to the office's equitable sharing agreement and what I believe that you're looking for, and I can tell you what I did to give you that.
Oh, okay, yes, that would be my next question. Well, that's jumping ahead, give me one minute to get there. So this response, so this one that you sent, and I don't have the date, you've got my copy, it was sent, I believe, January 26th, correct?
Yes, January 26th.
Okay.
I agree.
Can you pull up merchant 0018? So after that, on January 28th, we received something that says apologize for the delay. So after we received this letter, there was an apology for the delay and said that it was still pending.
I'm looking at, what date, January 28th?
January 28th.
January 28th, it reads, this correspondence in response to our response, we apologize for have additional time needed to fulfill your request. January 28th, yes, it does appear that, if I can, on January 29th, it says all responsive documents were emailed to you on January 26th, 2024.
So I'm trying to take it one step at a time.
Understood?
My question is, on January 28th, 2 days after your letter, there was an open records response that said they apologized, that they needed more time, and that it was still pending, correct?
That is correct.
So
It
then-
appears to be, yes.
All right. Then after that, on January 29th, I received another response that said responsive documents were emailed to me.
On January 29th, and then it says it was emailed to you on January 26th prior. If I met, that was on about where the cyber attack was. So in an effort to communicate to my staff, to all requesters, including you and 1,000 others. We wanted to make sure that everyone has a response that things have changed. So to me, you got a letter on January 18th. I responded to you via email on January 26th. My staff went around this time, hey, let me tell everybody that there is going to be a delay because I don't know what's going on with the cyber attack. On January 29th, it was all responsive documents were mailed to you on January 26th. So I want to clear up that.
Yes, that's what I was trying to get at. So at that point, all you had given me was the equitable sharing summary, and you were saying that's all you have. That's all the responsive documents, correct?
Based on your open records request, that was all, all the documents. That's correct.
What efforts specifically did you do to locate the records I requested?
That was, I didn't know what you were talking about, but you said that this was filed with the county and local government authority. So because it was filed with the county and local government authority, I called the clerk. I said, hey, clerk, is there anything related to this particular account that I particularly filed?
So hold on, so you contacted the clerk in regards to this response?
Yeah, I contacted the clerk.
That's the clerk of court.
Clerk of BOC, I'm so sorry.
That's okay.
The clerk of who?
But Board of Commission, you said that I had filed with the Fulton County, a local government authority. So because I'm taking you at your word, if this is something that I had filed with them, I called the clerk of the Board of Commission, I'm so sorry, to say, hey, is there something that I filed with the clerk of the commission?
So when did you do that? When did you contact the clerk?
Probably any time between January 24th and January 26th, and I responded to your letter, because I had to get the copy to provide to you on the January 26th letter.
And you spoke with the actual clerk?
I don't recall.
Was it by phone or was it by email?
Can't remember.
Did you use a county phone?
I can't remember.
Were you in your office when you made that call?
I can't remember.
Was it a woman or a man?
Your Honor, objection. The answer was to check with the clerk. That should be it. What is the relevance of the gender of the clerk? This is irrelevant.
It's argumentative.
Okay.
I understand what you're trying to do about what maybe refresh his memory about who he spoke to, but you made your point. Let's move on.
I'm trying to find out who it is so I can ask them if they spoke. That's the only way I can ask that. But I'm going. So you talked with someone at the clerk and they said they don't have anything in regards to forfeitures?
That's not what they said. I said, hey, based on your request, right?
Mhm.
You said that you can we pull up your request so we can read it verbatim?
What's up?
Okay, sorry, glasses off. Can we go down? I'm sorry. It says, reports and itemizations that were required by law to be submitted to the county as a local government authority showing what was done with all property and funds obtained through forfeiture, including but not limited to reports showing the funds went and who was paid out of funds. That's what you did. What did I do? I called the clerk of court. I said, is there a report, clerk of board of commission? Is there something that I filed that deals with property and or funds related to forfeiture? They gave me the equitable sharing agreement. I gave it to you. In footnote 1, I said, we believe you are seeking the office's equitable sharing agreement and certificate. These records were filed. Again, I say responsive records are attached.
Who gave you the equitable sharing agreement?
I can't remember. I know who I called. I don't know who responded. I don't know, but I recognize that this was something that was filed with the local government authority. It dealt with property, it dealt with forfeiture. I sent it to you free of charge. I do know that.
And did they send it to you by email?
I can't remember.
Were any other searches performed?
No, because at the time I gave you exactly what you was looking for. You looked for reports and itemization filed with the local government authority. I called the county. I said, is there anything filed with this property and seizure? They said it's the equitable sharing agreement. Oh, here we are, responsive. Here you are, free of charge. Item number 6, address closed.
That's
So
it.
no other
You
searches.
did no other searches?
No.
So you didn't obtain the document that you filed, that you also had to file, talking about, the equitable sharing is the federal one. There's also a state one for state forfeiture funds. Did you file it? Did you search for anything in regards to that?
You educated me. Say it one more time.
There's a federal forfeiture law and a state forfeiture law. You have to file reports for both.
Did you say that in the open records request?
Did I tell you that you had to file reports for both?
No, you're distinguishing state versus federal, right?
You said you gave me the equitable sharing. Equitable sharing is a federal Department of Justice document. There's also a PAC document for forfeiture. Two different funds, two different tracking.
Received.
Did you give me anything about the state tracking?
No,
You gave me the federal equitable funding.
because that's what you asked for. You said, give me the documents that was submitted to the county, Fulton County, as the local government authority.
They're
So
both submitted to the county. My question is, you gave me the ones, the federal forms. Did you do any searches for the state forms that you are required to do for the county?
no, I did not. What I did do was call the clerk. The clerk said, I have a forfeiture account based, your open record says local government authority showing what was done with property and funds, to forfeiture. It makes no mention of the distinction that you're drawing today. What you're drawing today is completely different. What I did say is say, hey, I have a point of reference, local government authority. Let me call the local government authority. They say, I do have something through forfeiture. I get it, it's responsive. I say in my footnote, we believe you're seeking this.
Okay, my question is, did you do any searches looking for the state documents? Any searches?
No,
Okay, can you pull up merchant 0571?
but why would I? No, the answer is no. And I would not have done that because you said filed with the county. So why would I then say, hey, I filed with this county, but maybe she wants to look for the state? I do not, you and I don't think alike, clearly.
Let's back up first.
Mm-hmm.
The federal forfeiture statute requires you to do a document called equitable sharing.
This news to me.
You file it every year as part of your problem.
Objection, Your Honor. I'm sorry, assuming facts is not in the evidence and is also
It's in evidence.
Ms.
Very-
Merchant, let her give her objection.
yes, that is my objection.
I'm sorry, because of the crosstalk, I understood. Is your objection, facts not in evidence? Is that your objection?
It's not it assumes a fact that is not yet in evidence, that he filed this every year.
So, I don't really think there's a dispute that the DA's office actually files this document every year because they do, but
But whether or not he filed it every year.
I was gonna agree with you, right? That whether he has any knowledge of the DA's office's compliance and requirement to do so, I have no idea. But what I am gonna back up to is I think you've asked, and he's answered multiple times, what effort he made to comply with that request. And I think his testimony is that he reached out to the clerk of the Board of Commissioners, and they shared with him information about this equitable sharing agreement. He believed that was responsive to your request, and so he identified it, produced it to you, and that was the end of what he believed was his response. That's what I understand to be the testimony at this point. And let's move on from here.
If you look at the merchant 0571, is that your name on the front of the document?
Could educate me, this document is what? What is this?
All I asked is that your name on the document?
I see Tina, yes, Dexter Bond is on it, Dexter Q Bond is on it, yes.
And it lists you as a deputy of the circuit attorney operations division, correct?
Yes, but the email associated is now Natalie Zellner, last name spelled wrong, so.
Yes. Have you ever seen this document before?
Council has presented this to me,
The county attorney?
my council.
Okay.
Ms. Merchant, can you tell me why it matters if he's seen that document before?
Yes, because he said this is one of the documents I was asking for. And he's seen it, he filed it.
Hang on. You're asking him if he's seen it and if he filed it.
Yes. So
Okay.
first I'm trying to identify.
Now I understand why, that's all I asked, that's why you're asking, because you believe that document was responsive to your original Open Records Act request and he did not provide it.
Yes.
Is that fair?
Yes.
Okay, go ahead, Mr. Bond.
So, in your astute research, it appears that you show 3 different forms, right? In those 3 different forms, each year, there was a different file, right? So we do know the first year that you received, my name is not on it, okay? The second year,
I haven't asked for that either.
my name is
Hang
not
on,
on.
hang on. Sorry, I apologize. She didn't start it with the word objection, but that's what she's doing, is objecting to your answer, so I'm gonna deal with her objection before you continue your response. Yes, ma'am.
It's not responsive. I didn't ask about all those other ones. He didn't have his name on those. They're not relevant. If we can go through those, we can, but I'm asking about the one that he signed as an example, that this would be responsive, and it doesn't even have anybody else's name on it. So I wasn't gonna go through all those other ones.
Okay, so let me back up. Are we still talking about the document that's on the screen?
Yes.
Okay, you just said he signed it. I don't, Mr. Bond,
Sorry, I'm so sorry.
let's be clear about what representations we're making. His name appears on this document that, at least to my eye, appears to be electronically generated. So ask him factually based questions about his involvement in that document and its creation, and then we'll be good.
That's what I did, and he was referring to the other 3 documents.
And in fairness, I agree with you, and I've asked you multiple times, Mr. Bond, when she asks you a question, please answer the question she's asking, and then feel free to explain if you choose to do so.
Understood, Your Honor.
Now, let's back up, Ms. Merchant, and ask your question again.
The document that we're looking at, is this something that you file electronically as part of your job?
The answer is no.
No. Do you have anything to do with this document?
Not this document, the answer is no.
Do you have anything to do with the filing of let's see what they call them, the Civil Forfeiture Procedure Act documents?
We're not producing this document, the answer is no.
I'm sorry?
You said, do I have anything?
To do with the filing of these? These are filed with the
The
state.
answer is no.
So you do not participate in these documents being produced?
No.
So someone else would have submitted it under your name?
I cannot tell you what someone else did. I can tell you, and forgive me, I am going to go on a slight tangent, but I never signed my name Dexter Q. Bond. And 2, my name isn't signed here. It is typewritten, and I would think that whoever is the signer would have that corresponding email address. That name, Dexter Q. Bond, is something I don't go by, okay? As it relates to Natalie Zellner, that is misspelled, that last name is misspelled, and that email address, I would assume if it was an electronic file, I don't do this, it will go back to that particular email. But any indication that I was involved, I can tell you vehemently I was not. And then I can tell you as it relates to a type name that I did not sign, I do not type my name as Dexter Q. Bond.
So you've never seen this document before?
I did not say that. I told you counsel has provided me the document.
That's what I meant, before that. Have you ever seen it before council provided?
No, I haven't seen that. Because it appears, based on what you said, it was submitted to the state and it's submitted electronically. So that's what it appears. But again, I don't sign it. And what I do know, based on research, and as you know, that in 3 different of these state filings were filed by different employees, none of whom are me.
I'd like to ask a clarification question. So it says Deputy District Attorney Operations Division, and I think I understood your title is Deputy District Attorney of Operations, is that right?
Yes, that's right.
Okay, so even though you might not have done it, is it the job of the Operations Division of the District Attorney's Office to do these reports?
So I don't know. Let me
Okay.
explain.
Mhm.
I was presented with 3.
Mhm.
The first one was done by a game unit. The second one was done by a forfeiture unit. This one was done by, well, I don't know who it was done by, but my name was on it.
Okay,
So let's be very clear. I would not say, based on what you provided counsel, 1, 2, and 3, and based on who in my office did this state electronic input, it needs to be clear that some of those people are no longer in the office, so I cannot verify, but I don't know.
So is it fair to say that this document does exist within your office?
I would say yes. But it's also fair to say that this document is in response to your open records request.
So it does exist. Did you do anything to search for this document?
Not this particular document, no. Why? Because you asked for documents filed with the county. I called the county. I got the equitable sharing agreement. The equitable sharing agreement deals with the substance of your request. I gave you that free of charge, and I sent it to you on January 26th in the email. So no, I did not do anything looking for the state, because you did not ask for the state. You asked for the local government authority, Fulton County. That's what I did, and that's what the Open Records Act requires.
And just to be clear, my request was what the county, you had to actually do, what the law actually required.
That's not what your request is.
We can pull
Hey,
my.
hey, the request is what the request is. Again, I can read, and I've seen the request multiple times.
Yes. So, if you had sent an email out asking for documents that the county required to be filed, would you have gotten this in response?
If you asked me a hypothetical, if I would have did what, I would have got
We
what?
searched for this document. I'm trying to figure out, and I don't know, you gotta understand, I don't know how the DA maintains documents. These are documents that have to be maintained. So if you had done a search for it, or you had asked people for it, would you have been able to obtain this document?
Objection, Your Honor, this question has been asked over and over and answered over and over. I'd like to move on, if we can, please.
Actually, I disagree with you. I think this is actually a new question, which is where would this document exist if you had searched for it, would you have found it? And that is a different question than whether he created it or was involved in its
I
creation.
misheard the question.
That's okay, thank you.
If I received an open records request looking for this, yes, I would have been able to go to a forfeiture deputy or a gang based on how it was filed in the past. But again, this record is not responsive to your open records request.
Do you, as a matter of practice, as the open records officer, do you use email to request open records?
It depends.
So it's not a general practice?
It depends on what you're asking for. If it's something, again, if it's something for a standard invoice, like you have sent to me several times, on staff meeting, I would say, hey, make sure you get this, put this in the portal. So I cannot tell you, it depends on what you're looking for.
So you sometimes do it orally?
Yeah, sometimes I do it orally, sometimes I do it, yeah.
If you sent emails asking for it, would you have those?
If I send emails asking for it, what is it? What are you talking about?
The records requests?
Yes, if I would have sent email, but sometimes I would have, the emails would exist if that's your question. Sometimes I would say orally, sometimes I have my, someone else, hey, shoot this email to so-and-so to make sure, call so-and-so. So I don't, without you being specific, it's hard for me to answer your question because with 1,000 open records requests, there's no one set way onto how to meet my constituents' needs.
And I asked if you used email to request records, and then I asked if you said sometimes, or depends. If you did use email, my question is, would you have those emails and know exactly what you asked for?
If I, Dexter Bond, sent the email, yes, the email will be on on my email, my archive, my system.
And so you could provide that to the court so that we would know exactly what you did in response to this request, right?
These requests, you're starting general, then you're getting specific. I cannot follow your question, so I don't know. I told you several times, I don't know what I did on this specific request. You're taking what me saying general, and then you're saying, oh, well, you did do these. That's a correlation that you can't make, ma'am.
My question again was
Good.
if you used emails
If I did do
for
email
record requests,
for a specific record request,
if you used emails for a record request, we would be able to get those and see those, correct?
you will be able to request those, and yes, they will be there. If you're asking, do I delete emails, the answer is no. So yes, they're there. If I send an email, my emails are there.
Did you ask for any of these specific documents that we've talked about here today by email?
We talked about a lot of different documents, so it's gonna be very difficult for me to say yes or no, okay? We talked about the equitable sharing agreement specifically. I told you that there was no, I don't know if I sent the email. I told you that. So the framing of your question doesn't allow me to answer.
Did you ask for any of these specific documents that we've discussed today by email?
As it relates to critical mention,
Did you ask for any of the documents we discussed today? by email?
Maybe. I don't know.
Is your use of the phone or in person to request documents on purpose?
On purpose?
Yes.
I don't understand your question. What you mean on purpose?
Do you purposely ask for things orally or in person? Do
No.
that on purpose?
Do I do that on, I don't, no. No, the answer is no. That I don't do anything on purpose.
Have you been instructed not to put things in writing by email?
No.
Have you been instructed not to put things in writing, period?
By whom? No.
Anywhere.
No.
What is the office policy on the use of email and putting things in writing?
I don't understand the question.
Objection, Your Honor. So I'm trying to determine what the relevance is in terms of emails and the protocol for emails in the district attorney's office. What is the relevance here?
I think there's a tiny universe of requesting open records documents for purposes of his compliance. So I'm gonna sustain your objection partially, and ask you to reframe that question, because I don't know that the general policy of the DA's office regarding email is relevant here. Mr. Bond's understanding of any policy regarding Open Records Act requests by email is relevant. Go ahead.
Does the Open Records Act requirements or, disclosure, does that guide yours or your office's policy on putting things in writing?
Does the Open Records Act guide you? The answer is, I don't understand the question. Does the Open Records Act guide I don't even know if there's a policy. So you're making an inference that I cannot, you're assuming a premise there, right? And then you're asking a question. You need to simplify your question. What are you asking me? Because you're asking me, does the Open Records Act influence your policy? You have yet to ask me, is there a policy? What are you asking? Ask me what you're asking. That's a convoluted question that I can't answer.
I first asked you, what is the policy on the use of email?
For open records requests.
For open records.
The policy for email, use your email. And there's no policy. Look at the employee manual. You gave it to me. I don't know where you're getting at. I'm not familiar with the specific policy on use your emails this way because of open records. If you draw a correlation to two, forgive me, I don't understand. But there's no policy on emails as it relates to the Open Records Act. There are two entities that are different. So educate me on the correlation.
I had just asked you if there was a policy. So I think that's the first step. If there's any policy on the use of emails in regards to the Open Records Act, not to put things in writing.
And I answered that question.
If there's no policy, is that your answer? Because I didn't get it, I'm sorry. I mean,
Okay.
you asked me to rephrase it and then said it was confusing, but.
It's still confusing because you're rephrasing it the same way. What I'm telling you is there's no policy as it relates to emails as it relates to Open Records Act, right? Do you want to talk about Open Records Act? Do you want to talk individuals? What are you asking? But I'm answering your question as it's being framed. It's being framed poorly, so you're getting a poor answer.
Can we take just a couple minutes break?
Very couple of minutes.
Okay.
Do you have water, Mr. Collins?
I'm sorry.
Do you have something to drink or anything? You've been sitting there for a long time.
I know, it has taken a long time.
Here, this is actually an open bottle of water.
I appreciate it. Thank you so much. Thank you.
Judge, but I think everything gets picked up, so.
I don't blame you. I'm consistently advising people when Zoom is on, the microphones are there, so.
Okay, I'm almost done, I promise. I'm sorry. In response to the subpoena to come here today, did you search for any emails?
Okay. Did I search? I sent your search terms because your subpoena to me was asked for to and from emails. It gave search terms. I believe there was 2 search terms, critical mention and social media monitoring. So what I did do is fill out a ticket, as I do with most requests. I sent that over to the IT department based on what you're seeking. Were there any responsive documents?
Hold on, so if you need to request something from IT, you fill out a ticket for that?
If you give me search terms, so there's 2 different ways, right?
Okay.
So let's say you're looking for documents, and if your document says, hey, give me anything for critical mention, I can then do, hey, do you have these emails? Does this make sense? That's one way to do it, right? Your open records request originally, don't need to be belabor the point, didn't answer that. Your second subpoena was very specific. It was this date to that date. From this email to this email. Here are the search terms. I need these search terms. I can then do a particular ticket, or my staff can do a particular ticket, do it to CIO, the technology department. The technology department can run all emails. And then when they do all emails, they can come and say, hey, based on these search terms and based on my word ticket, here are responsive documents.
Okay. So if you had asked IT for any of our open records items before, there'd be some ticket for that.
There will be some form, some Excel sheet, some requests.
And you didn't bring any of those here today.
Did you ask for them? No, I don't. As I shouldn't. Well,
But those would be available. If you had asked IT for any documents, there would be a record.
I'm not the custodian of IT records. I cannot speak for IT department, so I cannot answer that question and cause speculation.
Okay, let's just walk through the subpoena quickly. I asked for all text messages sent by or received from employees. What did you do in response to that?
That's an IT question. We needed to figure out what the policy was as it relates to text messages, so I would fill out, hey, IT, this is what I'm looking for.
Did you do that in regards to the subpoena? I'm talking about the subpoena for you to bring documents today.
The subpoena, yes, and I gave you, hold on, let's be very clear. You did not give me no subpoena to bring documents today. Let's clear up the record. What you did was you gave me a subpoena on August 21st to produce records, right? Those records were produced on August 30th. So there is no requirement for me to bring anything today. And I gave you those documents through my counsel on August 30th. So let's clear up the record. There's no requirement of me to do anything.
Talking about the subpoena for you to appear today. The subpoena for you to appear today had an exhibit that asked for emails and text messages sent by or received from in regards to critical mention. What I'm asking you is
I need to
what
see
you
the
did.
subpoena. I don't know what you're
Hang on,
talking
let
about.
her, I understand, but let her finish her question. Y'all can't talk over each other.
I'm asking what you did in response to that.
I hear you. I don't know what subpoena you're referring to. What I am telling you is I got a subpoena that was for the production of records for August, and I gave it to you on August 30th. That's what I'm familiar with, so I can speak to that. If you're speaking of a different subpoena, you can hand it to me and I can review it.
You learned about court here today, correct? Somehow, you knew to be here.
So are you not going, okay, different question. Somehow I need to be here. Yes, my counsel told me that I need to be here.
And you received a subpoena to be here today, whether it be through email or you signed a certificate.
No, I did not.
You didn't get an email with a.
You probably gave me an email. You probably gave me an email.
So
I'm pretty sure you gave me an email.
I'm sorry?
I'm pretty sure you emailed. Yeah.
And attached to that email, there was a subpoena that included the production of documents, correct?
What subpoena are you talking about? There are multiple subpoenas. I've asked you several times, can I see the subpoena you're referring to? If you're talking about the one to me on August 21st, I can respond and tell you what I did. You asked about a different subpoena, I need to be educated. I'm asking, I don't know what you're talking about, so I cannot respond. Are you willing to present to me something?
Of course, and I'm certainly not trying to hide anything. I'm trying to ask questions before.
I hear you, and I'm certainly trying to be very, very truthful to the court and clear the record. In order for me to do it, because there have been multiple subpoenas, all I'm asking for, if I am under a subpoena, and as you allege that I was supposed to bring something today, that's the allegation that you made among many, I would like to see it. That's all I'm saying.
Judge, his counsel's already talked about that, and I was understanding that he waived any issues with the subpoena to be here today. If that's not the case, I'm happy to show it to him, but
So-
without that, without him here.
I mean, so, okay, first of all, it's 4:59, so I need to check in with the court reporter who said she had a hard push at 5:00. Now, I don't wish to interrupt in the middle of questioning when it looks like you were trying to get to a point of being done with the witness, but as you can see, my screen starting to drop off, that's an indicator that my Zoom is about to die. So that's an indicator that we should adjourn. Separately, I will say, I agree with you, I think, that Ms. Alavi agreed to produce Mr. Bond. That's a different question, though, than whether he received and was aware of the document request. So we'll just leave it at that for now.
And that's fine, I'm happy to answer those, but I know he was sequestered and didn't know what his
Right.
counsel had agreed to.
Sorry, I can't hear Ms. Merchant.
I know that he wasn't present and didn't know what his attorney had agreed to. And so I just, before we went down that road, I didn't know if he knew that they had agreed that he was here and subpoenaed him.
Well, can I respond now?
You may, and then we're going to adjourn because I have to let the court reporter get on with her day since she's filling in.
I'm so sorry, this is definitely important. No, I'm glad I asked. I did not receive a September 13th subpoena. And let me clarify, because you need to know this. The subpoenas that you refer to, my name is not even on Exhibit A. So this is the first time, as I sit here today, that you have given me a subpoena that you said that I was responsible for. So no, I did not get this. It does not say when it was delivered. I have not received anything, and I don't know what was mailed. So no, I did not get this, and I'm not responsible for it.
Okay, and Judge, we've already put in the record the, when it was delivered, and I can put the email in where it was served. I'm happy to print that out tonight, and then we can question tomorrow.
So why am I not on Exhibit A? Something's wrong with that subpoena. Something's wrong with that subpoena.
Sir, that's a legal argument that your counsel can make. We've had some discussions this morning before you were called in to testify. And so we can have that conversation tomorrow. But it is 5:02. The court reporter did everybody a favor by rearranging her schedule to stay for an extra hour. I assume we have on board a court reporter for tomorrow. For now, I'm going to excuse Mr. Bond.
Thank you.
We step outside.
The document is up here.
Oh, thanks.
Mr. Bond, just reminder, Mr. Bond, that you're still testifying. And so you're still sequestered, right, regarding the substance of the hearing. And I'll need you to return tomorrow. I'm going to discuss with these lawyers in just a moment about what time I'll need you back, but just a reminder, okay?
Yes, ma'am.
Thank you, sir.
And not to review any of the, stuff today.
Well, I reminded him of his obligation under the rule of sequestration. So he's a lawyer, as I understand it, so I assume he understands.
Well, there's important new polling tonight showing that Kamala Harris has expanded her possibilities of winning the Electoral College. And this polling was done before the presidential debate, in which Kamala Harris crushed Donald Trump like no one has ever been crushed in a presidential debate before. So the polling could become even better for Kamala Harris once the effects of the debate register in the next wave of polls. Karl Rove saw this coming 14 years ago. Karl Rove saw this coming long before any other Republican. Karl Rove was the first Washington Republican to fear Kamala Harris. In an op-ed piece for the Wall Street Journal under the headline, "A Catastrophic Debate for Trump," Karl Rove writes, quote, "Tuesday's debate between Kamala Harris and Donald Trump was a train wreck for him, far worse than anything Team Trump could have imagined." President George W. Bush privately used nicknames for people around him. He called Vice President Dick Cheney big time. George W. Bush called his Treasury Secretary, Paul O'Neill, Pablo. The most well-known nickname in the Bush White House was one that George W. Bush didn't come up with and did not like: Bush's brain. That is what everyone else in Washington called Karl Rove, the senior advisor in the Bush White House who masterminded George W. Bush's winning presidential campaigns. Early glowing profiles of Karl Rove during the Bush administration eagerly platformed Karl Rove's theory that he was building a permanent Republican majority in the Congress and a permanent Republican Electoral College hold on the White House. Karl Rove was repeatedly presented in major media profiles as a visionary Republican strategist who was far, far ahead, not just of other Republican strategic thinkers, but all political strategic thinkers in Washington in both parties. Those profiles were the product of the standard groupthink of the Washington press corps, and they all wildly exaggerated Karl Rove's genius. But what was true was that Karl Rove really was thinking about electoral politics for Republicans in a more careful and data-driven way than any other Republicans. It was also true that Karl Rove had a pretty good eye for potential political talent. Karl Rove signed up with George W. Bush in Texas because Rove believed correctly that George W. Bush could go all the way to the White House. And as soon as Karl Rove saw Kamala Harris 14 years ago in 2010, he was very worried about her.
We are the state that creates leadership for the rest of this country based on our belief that we can be tough and we can be smart and all the time be dedicated to our history while being empowered to know our destiny.
That was the night in 2010 when San Francisco District Attorney Kamala Harris won the Democratic nomination for Attorney General of the state of California. And that video was not seen anywhere outside of California. Karl Rove saw it. And that is when Karl Rove got scared, because Karl Rove saw the same track to the White House for Kamala Harris that I saw, beginning with her winning her first statewide race as Attorney General in California. That would leave Kamala Harris perfectly positioned, and it did leave her perfectly positioned to run statewide again for United States Senate, which became possible when Senator Barbara Boxer decided not to run for re-election in 2016. Once in the Senate, Kamala Harris would obviously be a star who everyone would then expect to run for president. The key for Karl Rove was preventing Kamala Harris from winning statewide in the first place, stopping her in that Attorney General campaign. Karl Rove needed to turn Kamala Harris into a loser then so that she couldn't follow an Obama-like trajectory through the United States Senate to the presidency. It was that obvious to Karl Rove then. And so Karl Rove helped fund a negative advertising campaign against Kamala Harris in 2010. Joining me now from Los Angeles, California's Democratic Attorney General candidate, Kamala Harris. Kamala, can you tell the country the story behind that ad that Karl Rove is running against you?
Well, Lawrence, about a week ago, we learned that Karl Rove and Gillespie put together about $1.1 million in money to fund an independent expenditure attack ad against my campaign focused on Los Angeles. We also learned that the expenditure was funded by tobacco, oil, and insurance companies. And as you have mentioned, there's a lot of speculation about why. But what that tells me is that they clearly know that we can win. And they obviously don't like our position on many of the issues that I believe are important, clearly not only to California, but the rest of the country.
Karl Rove was right. They needed to stop Kamala Harris then, or someday Republicans were going to be very worried in a campaign for president against Kamala Harris, as they are worried tonight. Kamala Harris won that first statewide campaign by less than 1% of the vote in California. And that is why she is where she is tonight. She is polling 4 points ahead of Donald Trump in the latest Wisconsin poll. The Marquette University Law School poll, the most trusted poll in Wisconsin, shows that among likely voters, Kamala Harris is polling at 52 in Wisconsin and Donald Trump is polling at 48. That is in a state where the last two presidential elections have been decided by less than 1% of the vote. In 2016, Donald Trump won Wisconsin with 47.2% against Hillary Clinton's 46.5%. And in 2020, Joe Biden won Wisconsin with 49.4% against Donald Trump's 48.8%. That's how close it's supposed to be in Wisconsin. A 4-point gap in the Marquette poll in Wisconsin among likely voters is more than what Democrats could have reasonably hoped for at this point in the campaign. And that polling was completed before Wisconsin watched what Karl Rove saw in that debate, which Karl Rove describes this way. Ms. Harris was often on offense, leaving Mr. Trump visibly rattled as she launched rocket after rocket at him. A New York Times analysis found she spent 46% of her time on the attack, while Mr. Trump devoted 29% of his time to going after her. Debates aren't won on defense. Ms. Harris pressed Mr. Trump on the economy, the Ukraine war, foreign policy, healthcare, the January 6th attack, and especially abortion, leaving him flustered and often incoherent. Mr. Trump had to know the vice president would try to get him to lose his cool. She did. She went after him on his multiple indictments. She called him weak and belittled him as a 6-time bankrupt, spoiled inheritor of wealth. She said his former national security advisor thought him, in her words, dangerous and unfit for the Oval Office. He took the bait almost every time she put it on the hook. Rather than dismissing her attacks and launching his strongest counter-arguments against her, Mr. Trump got furious. As her attacks continued, his voice rose. He gripped the podium more often and more firmly. He grimaced and shook his head, at times responding with wild, fanciful rhetoric. Mr. Trump offered angry responses, pursed his lips and eyes darting mostly down, seldom looking at her. And what was it with his makeup that left white circles around his eyes? Professional Republicans take Karl Rove very, very seriously. Big money Republican donors have always taken guidance from Karl Rove very, very seriously. They believe that Karl Rove really was Bush's brain, especially in campaigns. And so Republicans reading Karl Rove's assessment of the debate in the Wall Street Journal is as depressing as watching the debate was for those Republicans. Karl Rove continued, "It matters how debating candidates carry themselves. There, it was no contest. Ms. Harris came across as calm, confident, strong, and focused on the future. Mr. Trump came across as hot, angry, and fixated on the past, especially his own. She mastered the split screen, projecting confidence and wordlessly undercutting him by smiling while shaking her head as he spoke. Many undecided and swing voters will make up their minds less on any single issue than on their visceral reactions to the candidates. Ms. Harris did herself much good with that crowd Tuesday. Mr. Trump didn't. Even voters wanted to learn something new and reassuring about the candidates in the debate. She provided them plenty while he didn't. There's no putting lipstick on this pig. Mr. Trump was crushed by a woman he previously dismissed as dumb as a rock, which raises the question, what does that make him? The answer to that question was provided by Kamala Harris in the debate.
I have talked with military leaders, some of whom worked with you, and they say you're a disgrace.
You know who won a debate when one candidate uses the debate in a campaign commercial and the other doesn't.
I want to turn to the issue of abortion.
For 52 years, they've been trying to get Roe v. Wade into the states. I did a great service in doing it. It took courage to do it. And the Supreme Court had great courage in doing it.
I have talked with women around our country. You want to talk about this is what people wanted? Pregnant women who want to carry a pregnancy to term, suffering from a miscarriage, being denied care in an emergency room because the healthcare providers are afraid they might go to jail, and she's bleeding out in a car in the parking lot. She didn't want that. Her husband didn't want that. A 12 or 13-year-old survivor of incest being forced to carry a pregnancy to term. They don't want that. I think the American people believe that certain freedoms, in particular the freedom to make decisions about one's own body, should not be made by the government.
I'm Kamala Harris, and I approve this message.
Here is what debate winners say.
So North Carolina, 2 nights ago, Donald Trump and I had our debate. You watched it? Did you watch it? And look, I believe we owe it to have another debate. Right? We owe it to the voters.
Another debate. And here is what debate losers say. There will be no third debate. So says Donald Trump. Vice President Harris went to North Carolina today, where she has opened up the new possibility for Democrats to win the Electoral College with North Carolina's 16 electoral votes. The Democratic presidential candidate has not won North Carolina since 2008, when Barack Obama did it in his first presidential campaign. Donald Trump has won North Carolina twice now. If Donald Trump loses North Carolina this time, that would virtually eliminate any Trump chance of winning the Electoral College. With recent polls in North Carolina showing a 3-point gap between the candidates, the most recent poll shows Kamala Harris at 50 and Donald Trump at 47. If that's what happens on Election Day in North Carolina, Kamala Harris will be president. Here is North Carolina Governor Roy Cooper speaking to NBC's Nnamdi Egwuonu tonight after Vice President Harris's campaign event.
There's a reason why Donald Trump spent more money in August in North Carolina than any other state, because they're panicking. They know that Kamala Harris is at least tied or maybe even taking the lead in North Carolina. Donald Trump has no other path to the presidency. He must win North Carolina. We know that if Kamala Harris wins North Carolina, she is the next president of the United States. We did this in 2008. North Carolina voted for Barack Obama and made history. North Carolina is ready to make history again.
Here's Vice President Harris in Greensboro, North Carolina, earlier this evening.
Donald Trump intends to end the Affordable Care Act. Now think about that. Think about that. We remember what it meant when insurance companies could deny you for a pre-existing condition. Remember what that was? So he wants to get rid of it. And as he said in the debate, he made clear he has no plan to replace it. In fact, you remember? Concept. You remember? He has, quote, concepts of a plan. Concepts of a plan. I mean, we're 54 days from this election. Concepts of a plan. Which means no actual plan. Which means no actual plan. And 45 million Americans are insured through the Affordable Care Act. So understand what that means. He's going to end it based on a concept and take us back. So generations of Americans before us led the fight for freedom, and now the baton is in our hands. The baton is now in our hands. And we who believe then in the sacred freedom to vote will finally pass the John Lewis Voting Rights Act and the Freedom to Vote Act. And we who believe in the freedom to live safe from gun violence will finally pass an assault weapons ban, universal background checks, and red flag laws. So much is on the line in this election. And we got this. We got this. But look, here's the thing. This is not 2016 or 2020. The stakes are even higher. And let us be very clear. Someone who suggests that we should terminate the Constitution of the United States should never again stand behind the seal of the President of the United States. Never again. Never again. Never. And put that all in the context of people who have been talking about how he was when they served with him in the White House. People who saw him every day. His national security advisor, his defense secretary, his chief of staff, and his vice president. All of whom have warned America Donald Trump is not fit to be president of the United States. And should never occupy our nation's highest office again. We know ours will be a very tight race until the very end. We are the underdog. Let's be clear about that. We are the underdog. And so we have hard work ahead of us, but we like hard work. Hard work is good work. Hard work is good work. And with your help, we will win. We will win. And so I ask you today, North Carolina, are you ready to make your voices heard? Opportunity. Do we believe in the promise of America? And are we ready to fight for it? And when we fight, we win. There you go. God bless you, and God bless America.
Kamala Harris accomplished everything she needed to last night. She needed to accomplish a lot, knocked it out of the park. The vice president's known for being a politician who really prepares, and it was clear that she took her debate prep very seriously. Philippe Reines is a former Deputy Assistant Secretary of State and former spokesman for Hillary Clinton. And Reines played the role of Donald Trump in Clinton's debate prep back in 2016. There he is in what appears to be a kind of like a flip phone video in costume, role-playing a scenario where Trump tried to hug Clinton and then chased her around the room for said hug. Reines reprised the role of Trump in Kamala Harris's preparations for last night's debate, self-tenor and all, and he joins me now. Philippe, it's good to have you. First, what do you think of that debate?
I could watch it all night. I mean, she put on a clinic. There's no part of it you can watch that says that's bad. She should have redone it. It was a remarkable performance. I know the former president is saying the same thing, but as usual, one of them is lying and one of them is not.
So take me through the prep. First of all, what was your approach in that prep to playing Trump? And what are the kind of signature things he does in debates that you were doing? And then how was that kind of gamed out and prepared for?
Well, first, my role in it is the kind of sexy part of it, but I really just had to focus on the left side of the screen, which is him. There's a team that helps the vice president that was headed up by Karen Dunn and Rohini Kasula, who, I mean, it was amazing. And it was a frictionless team that I've worked with other teams, and it was great. The vice president has great people around her. I mean, it was not just the two of them, but they co-ran it. From my perspective, you just want the candidate to get used to what they're going to see and hear and experience. And there was that added oddity that they never met. And what's great is I had never met her. The first day that I met her, I said, Madam Vice President, it's nice to meet you. And then 20 minutes later, I was telling her how she was ruining America.
Did you, what was your approach? What are the most important things to prepare for if you're debating Trump? Like the sort of go-to moves, the things that might rattle someone who hasn't been in the same room with them?
Well, I would take it a step back. I mean, a debate in its ideal form is a job interview. You have two people who are going for the same position, who want to put their experience and their best foot forward. They want to be professional. They want to think about curveballs that might come their way. And you know, we've all been in that situation. The situation we haven't been in is when the other candidate for the job is 6 feet to your left and they've got a chainsaw, and the only way that they can win is by, you know, blooding you up. And the challenge there is, you know, you have to make some decisions. But what she did last night that was so amazing is that she wasn't just pointing out things that might get under his skin. She was making her case directly to camera to the American people. She was talking about her plans. And what was also incredibly amazing is that she did something that no one else has really been able to do in the last year, which is remind people that this guy actually served and has a record, and that record is really bad. And, you know, you've talked about this amnesia issue is a problem, where he starts out saying, you know, you completely screwed the border. It's got to be, hold on, pal. You were there for 4 years. You were in charge of the border, and you promised us a wall, and it's not there. And that hasn't happened enough, and it's important to lay out that case. And third, I mean, for my own, in terms of asking about prep, first of all, you know, we all get makeup before we're on TV, and the makeup artist here said, "You already have makeup on," and I said, "No," and she said, "Well, you've got it on your forehead. I can't get it off. I mean, it's so caked on." The guy uses, you know, like plaster of Paris. But the thing that I noticed over the 8 years, and by the way, I feel like it was 50 years when you say a flip phone. I mean, it wasn't black and white, Chris. Is that he's really decompensating. I mean, his language has always been choppy. He's always digressed. There's something else going on there. I think we all watch it and it's like, oh, he always speaks like that. He does not. He's losing, like, if I lose track of my thoughts, I stop for a second. When he loses track of his thoughts, he just goes to another thought quickly. So it doesn't sound like anything. It just sounds like he's jumping around. That's not what he's doing. He's also seemingly, he'll go off on COVID for 10 minutes and not say Tony Fauci. I mean, 4 years ago, he would go on for 5 minutes about Tony Fauci. So there's something, you know, I'm in the camp that has always noticed that, but just very narrowly in terms of watching everything he has said and done over the last few months and reading every word, there's something not right up there.
Yeah, and you know, we'll only play a little selection, and one of these selections, which we'll play in a second, is sort of notorious. They're eating the dogs, they're eating the cats, which of course is both a sort of disgusting and racist slander to a group of people, and also completely invented. But that answer came, he started on the rallies. Like we played that rallies clip. He got from like, people go to my rallies to that. And, you know, he cannot follow a train of thought. He interrupts himself. Here's just a little smattering of what that looked like.
She's a Marxist. Everybody knows she's a Marxist. Her father's a Marxist professor in economics, and he taught her well. In Springfield, they're eating the dogs, the people that came in. They're eating the cats. They're eating the pets of the people that live there. She was big on defund the police. In Minnesota, she went out. Wait a minute. I'm talking now. If you don't mind, please. Does that sound familiar?
He was very proud of that last one. He referred to it as cute, and he gave a little kudos to himself afterwards that he was like calling back a I'm speaking moment. In terms of the sort of set pieces, like the baiting, How much of that was planned? Like, it seemed to me that there were certain things that he won't leave alone. John McCain, Charlottesville, very fine people, the outcome of the January 6th election, his rallies that were intentionally seeded in her answers to get him to narcissistically obsess over them.
I think, look, she has seen him over the years. The guy's debated 7 times. This was his 7th general election. He debated, I think, 11 times in the primaries, notably 0 times in the 2024 primaries, and yet he calls everyone out for being scared. I think she was almost acting like she was watching it, like she was, kind of watching it on TV and saying, hold on, dude. I mean, what about this? Because that's what she was doing, was calling out facts. What's particularly, I think, telling when you show these clips of his digressions or whatever you want to call them is that they make no sense. So fine. He's not Rubik's Cube. He's not hard to figure out. He's Jenga. You just push one thing and he falls apart. But if you say your crowd sizes are low and people leave, why wouldn't you say that that's not true? That's very mean. I'm really proud. They're the biggest things. What he actually starts doing is a different level of insanity.
Yes.
I mean, you're revealing it's a subset. I mean, what he's saying has never been truthful. It has never been real. It has never been normal, but it is decompensating. And I think because it's, the thing about the frog, in water, if you just boil them slowly, they don't know what's happening. We've all been so kind of inured to it that we don't realize how serious this is. And look, Joe Biden, I love Joe Biden. When Joe Biden was 78 and he ran for president, no one thought, I'm concerned at how he looks. Donald Trump is 78. If he wins, we could be back in this conversation in 2 years. How are we supposed to know that he was going to go off the rails?
Did you do off the rails as him?
You do everything. I mean, I'm the ball machine.
I know.
You got good tennis player who wants to get better.